cause list, it is very clear, huh?
I want to mention, my lord, I have for bail custody since more than 13 years.
Then you give it. There you go.
I pardon me, Lord. But I pardon me, Lord. I want to receive, Lord. But item 64. This case I have filed an IA. I number 97 of 2024. Let it come next week along with that IM, Lord. Item 64.
Which is the item?
Item 64. JCRLA 40 of 2014.
64.
My lord.
It is in the hearing list.
Yes, Lord. I find a bail discussed. Already 2014 is in custody. Lord.
It's all right. That is why it has come for hearing. So get ready for hearing. You have must have received the paper book also.
Paper I have not received. Paper book I have received.
You received the paper book. Send one of your associate collect the paper book, or you yourself collect the paper book. Get prepared. We can take up the matter. All right. Yes.
One item, Lord. That item number 3, Lord. That the death reference connected, Lord. Item number 3, that connected death reference matter, Lord. That CRLA, I am convicted in the same.
No, it's all right. We are just condoning the delay. Actually, we are searching that why he did not file any appeal.
Yes, Lord.
Now the registry has placed it that in fact the appeal has been filed.
Yes.
And there is some delay.
Yes, Lord.
So we have to condone the delay. There is no problem, and you can argue the matter. You can hand over the paper.
My problem is let it on Friday.
You see, Mr. Sarangi has already exhaustively argued the matter.
Yes,
for both the appellants, not that. But since you are filing the separate appeal, we are definitely will give you opportunity to argue the matter as you like. But if you say Friday, there is it may not be. Why don't you argue Thursday?
Yes, deeply.
Okay. So. It which item number 3 CRLA number 693 of 2024, IA number 1516 of 2024. There is an application for condonation of delay.
293 days.
The staff reporter has pointed out that there is delay of 259 days in filing this criminal appeal. Stop. Since the appellant, the petitioner has been sentenced to life imprisonment. After hearing the learned counsel for both the parties, we are inclined to condone the delay. Accordingly, delay is condoned. IA is disposed of. Hard admit, since trial court record is already available. Trial court record is already available in JCRLA number 118 of 2023, filed by the accused Nabin Deori, so also in DSREF 1 of 2023. Stop. The Land Council let the registry supply the paper book to the Land Council for the appellant during course of the day. Stop. Mr. Das, Land Council, submit that the matter may be taken off on 25th of July 2024. এটা নিয়ে আসবে আপন আউথরে supplement at least 25th of in view of such submission, list this matter under the heading of hearing on 25th of July 2024 with DSREF 1 of 2023 and JCRLA 118 of 2020.
Diplomatized.
In this case, my lord, I have already filed the written note for argument.
अच्छा माने अपने जो DSREF रे तो
My lord.
अच्छा DSREF 1 of 2023 रे रखी देबे written note of argument has been filed by Land Council for the state. आज ही फाइल कर ले
My lord.
अच्छा filed by which is taken on record. Let a copy of the same be handed over to Mr. Devashish Sarangi. So you also supply a
My lord.
copy because he must have also dealt with the conviction of this Hemananda Dehuri.
Right.
So supply a copy.
My lord.
Let a copy of the same be supplied to Mr. Devashish Sarangi on an amicus curiae. So also Mr. Pranay Kumar Das, Land Council, who is appearing in CRLN number 693 of France. ये पेपर बुक आज देखिए रिसीव करेंगे आपण टिके रिसीव करे दे ऑर्डर शीट हां ताकू कहि दियो
Yes, but she yes. Business data.
Sample Procedural on
also period so period the prisoner's petition dated 18/7/2024 hala in which prayer has been made
To engage
by appellant Hemananda Dehuri to engage Mr. Pranay Kumar Das as his advocate. Khali pardon se ei jo CRLA number 693 re
हेमानंद तमे गोटे प्रिजनर्स पिटिशन गोटे देइथिलो जोथरे कि तमे प्रणय दास को तमर वकील भाव रे रखिया ले चाहिथिलो सेई तमर से दरखास्त को आज ग्रहण करके प्रणय दास को आज वकील भाव रे नै एई जो मुकदमार हियरिंग पई पुणी ताको कहिबा अनुसार गुरुवार को रखा आइछि हला
ନାଇଁ ନାଇଁ ଓକେ ତାଙ୍କୁ କହିଦିଅନ୍ତୁ ତାଙ୍କୁ ଖବର ଦେଇଦିଅନ୍ତୁ ସେମାନେ ଇଏ କରିଦେବେ ଏବଂ ସେ କାଳେ ଅପେକ୍ଷା କରିଥିବେ କୁହା ହେଇଗଲା ଫୋନରେ କହିଦିଅନ୍ତୁ ଯେ ପହର ଦିନ ଶୁଣାଣି you have to bring it in supplementary list ହେଲା
weekly list item number 6.
Item 6, your lordship, this file has come on transfer, your lordship. In the meantime, on 2-3 occasions, the file has been transferred, and last time it has come to me. So,
what do you want today?
My lord, that interim application in view of the noting, your lordship kindly sees for interim bill, that has already become infructuous.
Which one has become infructuous? There are two interim
Yes, two applications.
Both are infructuous.
Both have become infructuous.
What is your good name?
My name is Debabrata Ratha, your lordship.
Debabrata Ratha.
Debabrata Ratha.
All right, heard Mr. Debabrata Ratha, London Council appearing for the appellant. He submits that IA number 486 of 2020 as well as IA number 1919 of 2022, which were filed for interim bail has become infructuous. In view of such submission, both the interim applications are disposed of. Yes, sir. Now, this case paper book has already been filed.
Paper book
Have
filed?
you received the paper book?
I have got the paper book, but there are certain discrepancies, your lordship. In page marking, I was checking, I was verifying. There are some discrepancies in my
So you
paper.
get ready to argue the matter. 2012.
Yes.
12 years have already passed.
Yes, yes, your
We
lordship.
are adding it to the hearing list next week. Get ready and argue the
Yes,
matter.
your lordship. Yes, your lordship.
Mr. Rotho, the London Council appearing for the appellant submits that he has received the paper book and the matter may be added to the hearing list next week. List this matter in the week commencing from 29th of July 2024 for hearing. Okay.
Obliged, your lordship.
Your lordship, and with due apology.
Yes.
Written note of submission I have given to my learned friend Mrs. Sahoo.
Mrs. Sahoo, she has already said, and we have noted down it. And we have also asked her to supply a copy of the same to Mr. Devashish Sarangi Lanen amicus curiae and Mr. Pranay Kumar Das, who has filed CRLA for the appellant Hemananda Dehuri. Now, this matter, Mr. Katkia, it will be listed day after tomorrow because Mr. Das wants to argue the matter. So obviously, opportunity is to be given. So you remain present day after tomorrow. Only.
I'm present.
Okay. Oh.
Okay.
Item number 7.
May I please?
Yes, Mr. Jafullah.
7, my lord. Today I have already given my pen drive to collect the deposition copy. Kindly this matter will be taken up tomorrow, my lord.
Just a minute. What order was passed last time?
Last time delay content admit LCL call for my.
ତାପରେ ଆଉ କିଛି ହେଇନଥିଲା।
No, that was in
ଆଜ୍ଞା।
2013.
13 ତାପରେ ଆଉ କିଛି ଖାଲି delay content ହେଇଥିଲା। I filed an interim application for bail and stay.
No, that is there in the weekly list. You get ready, you can taken up tomorrow.
My lord.
It is for the entire week, there is no problem.
My lord.
The kali rakhiye. Pen drive madam ko dei de jaha che shaam ko.
କପି କିନ୍ତୁ ଡିପୋଜିସନ କପି ମୁଁ ସର୍ଭ କରିଛି ତାଙ୍କୁ।
କହୁଛନ୍ତି pen drive ନବା
pen drive I have already served copy of the deposition previously.
all right miss.
ଆଜ୍ଞା ଠିକ ଅଛି ମୁଁ ଦେଇ ଦେଇଛି ଗୋଟେ କପି ଏକ୍ସଟ୍ରା ଦେଇଛି କହିବେ ବି ମୋ ପାଖରେ ଅଛି ଡିପୋଜିସନ କପି ଗୋଟେ।
She will take in her pen drive. What is there? Yes, next.
Tomorrow.
Item 8.
Yes, it's tomorrow. It will be there in the weekly list. Okay. Yes. Yes, Mr. Sanjeet Kumar Das. Not there. Pass over next.
Item number 9.
Again, Sanjeet Kumar. तो तांको हमें एंगेज करथुलु ना तारपरे क्वाइल तम क्वाइल डिपोजिशन कॉपी हमें कहथुलु नै जिवे बोली पेन ड्राइव रे पड़ गले मिसेस साहू
My lord.
मिस्टर दास के खबर देबे
My lord.
संजीत दास
My lord.
Item number 10.
You are there, Mr. Jafrullah. Item 10.
ମୁଁ petition number 1 appellant 1 ପାଇଁ Mr.
I'm here for number 4.
4 and Mr. Karunakaran. That Sheikh Bazaar case. That Sheikh Bazaar.
No, it's all right. Why it was brought in person? So and so. It was taken on 15/7. All right. 15/7 it was taken.
Report ମାଗିଥିଲେ ଯୋଉଟା.
Appellant number 1 is filed.
Called for a report regarding
of the deceased appellant.
Just tell it is so and so and counsel appellant filed comprehensive evidence. Then Land Council also files instruction dated so and so received from so and so in respect of the criminal antecedent. Then let a copy of the written instruction be supplied. Okay. Land Council for the state further submit that the matter may be taken up next week in order to obtain report from the Superintendent of Circle Jail Chaudhary as to whether appellant number 5 so and so is dead or not. There is some criminal Land Council to the Asila. I want to keep the knife. In portions of the order dated 15/7 2024. The Learned Council for the state has produced the report dated 18/7/2024 of Senior Superintendent Circle Jail, Cuttack at Chaudhar, wherein it is mentioned that the appellant number 5, Tony alias Subhranshu Kumar Das, expired on 9/3/2019 by undergoing treatment at Civil Medical College Hospital, Cuttack. The report is taken on record. So now this appeal will be confined to appellant number 1 to 4. So where is Mr. Mahapatra? He was appearing for rainy day. Do you argue this matter today or tomorrow?
We can do it tomorrow. I'll be in difficulties. I've got some cross-examinations fixed tomorrow and day after. Can we do it after lunch?
Mr. Sarangi,
I got the
you must have.
Somebody else has filed another appeal.
That is for that appellant who has been sent. So we are taking up this matter on
that. Your lordship clarified him on the other day. He is arguing for both. I also told the local lawyer the total hearing is going on. It's not personally for one person.
Or some sort of information given. So now he has filed that written note of argument. You must. We are asked to give you a copy of this. Mr. Katkia has filed.
He rang me up. His mother is undergoing.
And this matter will be taken up day after tomorrow. And
may conclude it on that. Whatever he submits the.
No, it's already. He said that. We said that Mr. Sarangi has already covered for both the appellants. He said that he is to argue.
Yes, because the private.
Private he has engaged. So Mr. Panda, we can. Mr. Mahapatra is not there. We can take up after.
My lord, in this case, my lord, Mr. P.B. Tripathi conducting this case, my lord, he was in ill, so that this matter may be taken up next week, my lord.
Tripathi was conducting this case.
My lord.
Will it not be available on this Thursday? Or is.
I will inform, my lord.
No,
let it come next week on next Monday.
All right, put up this matter.
In custody a week
a mention is made on behalf of the Learned Council for the state that Mr. Priyavrata Tripathi, Learned Additional Standing Counsel, is to argue the matter on behalf of the state of Orissa, and he is not well. The matter may be taken up next week. Learned Council for the appellants number 1 to 4 have no objection to the same. Put up this matter under the heading of orders on week commencing from 29th July 2024.
Only one thing your lordship may note that I have filed a comprehensive affidavit on behalf of appellant number 4.
Mr. Devasis Panda, Land Council, appearing for appellant number 4, S.K.Sahoo alias S.K.Sahoo, has filed a comprehensive, comprehensive affidavit, serving the copy of the same.
Yes, I have served a copy on the state. I'll serve a copy on Mr. Mahapatra's assessment.
Serving copy on the Learned Council for the state. Let a copy of the same be also served on Mr. Sorochandra Mahapatra and senior advocate.
Not on him, Miller. On advocate on record.
Mr. All right, Mr. P. Mahapatra. On the
Mr. Panda is keeping me.
No, I am not doing that, my lord. I was associate of Justice Lingaraj Ratha, who was a senior advocate. I have never mentioned on his behalf. In fact, his lordship used to caution us not to mention on his behalf.
It's all right. Copy we served on Mr. P. Mahapatra, Land Council, who is appearing for the informal. All right.
My lordship directed, last occasion, lordship directed to file an CA and custody certificate. I have already submitted.
The custody certificate filed by the Learned Council for the state for the appellants number 1 to 4.
Regarding CA 1 to 4, my lord. Regarding custody certificate, only one.
Custody certificate of କାହାର କଷ୍ଟଡି ସାର୍ଟିଫିକେଟ ଫାଇଲ କରିଛନ୍ତି appellant number 1 appellant number 1 ବିଶ୍ୱଜିତ ବେହେରା alias ବେଲୋର ହେଲା and criminal antecedent in respect of appellants number 1 to 4 filed which is taken on that which are taken on. Mr. Mahapatra, it will come next Monday.
Item number 11.
May I please? The prisoner person have come in the list.
Yes, he wants to engage you, and you have also filed BNAMA, right?
Yes, madam.
All right. Paid you the prisoner's petition at flag X for engagement of Mr. Vibhuti Bhushan Rautray, advocate, as his counsel. Mr. Rautray has filed the BNAMA. BNAMA is accepted. The it is a case where single appellant or
Single appellant.
the name of other learned counsel except Mr. P.V. Rautray shall not be indicated in the cause list. Upon associate की file कुछ ना single BNAMA. अच्छा, then except Mr. P.V. Rautray. Yes, now you can argue the matter.
Yes, madam. The appellant is custody since minute.
It a main CRL liquidity. Yes. Then you come to that bail application which to argue. Yes.
And the convicted is 302 minute. Sentenced to undergo arrive for life. And he is in custody since minute 27/9/2012. About 12 years in custody.
27/9.
Yes, madam.
2012.
Yes, madam.
Okay.
And here the allegation that the petitioner.
You have your earlier bail application have never been rejected by this court.
Never been.
Okay. So 302.
302, madam.
What is the name of the deceased?
My deceased name is Madam Tara Naik. Tara Naik.
Tara Naik. And date of occurrence?
Date of occurrence, Madam 26/9/12.
Eyewitnesses are there?
Yes, they are, Madam.
Who is the eyewitness?
The PW 2-3, Madam. 2-3-4.
2, 3, and 5.
No, 2-3-4. Yes.
5 also.
Yes.
PW 2, 3, 4, and 5
yes.
are the 4 eyewitnesses.
Madam.
And who is the doctor who conducted PM?
Madam, the PW 10, Madam.
PW 10. How many blows you have given and what is the weapon of offense?
That is Madam. That is Hatha Barisi, Madam. Barisi. Out of anger, Madam. The PW 5 and the petitioner's daughter went to bring BD from the shop, and the appellant asked her mother why she sent the petition daughter to the shop for bringing the BD. As a quarrel between both the parties, the deceased and the appellant, out of anger, the deceased took up a Hatavaris and assaulted the deceased by means of that weapon of offense, and he has sustained 2 injuries. It's a sudden provocation,
Barisi is a sharp cutting weapon.
Yes,
meant for cutting wood. Acha. Preparation of furniture. Outside of the songs. Hold on. Into the So you are in custody for about 12 years.
12 years, Madam.
Paperwork perhaps has not been prepared.
Not prepared.
Any criminal antecedent, Mrs. Sahoo?
Regarding criminal antecedent, I don't know such order passed before Your Honor, my lord. I will take instruction regarding the CA, my lord.
Take it to which police station?
It is from
Atmalik. Atmalik on to. So it can be taken up next week. You obtain the instruction.
My lord.
Lekhundu IA number, miss case number 1152 of 2015. This is an application for bail. The Learning Council for the petitioner submitted that the petitioner is in judicial custody since 27/9/2012. The Learning Council for the state submitted that the matter may be taken up next week in order to obtain instruction regarding the criminal antecedent, if any, against the petitioner. Please this matter in the week commencing from 29th July 2024. Yes.
Item number 12.
This case number one. So stay
They were adjournment. Pray for adjournment on behalf of S.K. Divedi.
So when you want it?
1 week after.
1 week after. All right. Miss case number one. So this is an application for bail. Mention is made on behalf of Mr. Suryakant Divedi for adjournment. Please this matter in the week commencing from 5th August it will come. 5th August.
Last occasion, lordship directed to custody certificate regarding the instruction custody certificate. See, I have already obtained.
The Learning Council for the state has produced the custody certificate. So also instruction regarding the criminal antecedent which are taken on record. Yes.
Item number 13.
Well, can I see?
The order indicates last time we passed the order. It is stated at the bar that appellant number 1, Rupo Naik, appellant number 7, Punia alias Sagar Naik, and appellant number 8, Sujan Naik are dead. Let the Learning Council for the appellants obtain instruction in respect of such statement made through the instruction upon
Tomorrow, my lord, this matter. I will obtain instruction regarding that matter.
Inspector in charge to obtain karibe.
My lord.
Letter received from the trial court regarding death of. As a 7 ta asi jaichi. Baki aur rahila appellant number 1 Nupo Naik and appellant number 8 is Sujan Naik.
Nupo Naik died on 25/6/2020.
It's all right. He has to just confirm with that because the appeal will appeal against those appellants. So that's just. So it will be taken up tomorrow.
My lord.
My lord, can it be taken up
next week? All right. The Learning Council for the state seeks some time to obtain instruction regarding the death of appellant number 1 Nupo Naik and appellant number 8 Sujan Naik. Put of this matter in the week commencing from 29th July 2024. Yes.
Item number 14.
Last occasion also direct custody certificate.
Let us see that order.
Sasha police.
Yes, yes. PRL number 710. Yes, Mrs. Sahu.
I've already obtained.
What is the $13 years, 4 months? What about criminal antecedent?
Nothing adverse against him.
This is item number 14, 720, 720, criminal appeal. Bada shukar, single appeal. Appeal 386 of 2000 instead of the Vinamana of High Court. That is a true 30 of body. CRLA number 3 in such bias. In such high study work. 386 of body. Criminal appeal number 15 CRLA number 386 of 2014. This criminal appeal has been filed by 3 appellants, namely Buddhanath Jena, Munna Mahanti, and Kailash Chotrai alias Kalia. Since Kailash Chotrai has filed a separate criminal appeal, that is CRLA number 720 of 2016, this CRLA will be confined only to appellants Buddhanath Jena and Munna Mahanti. Now you come to that 720 of 2016. Yes, so the custody period we have seen and no criminal antecedent. So what is your role? What you have done?
My lord, conviction was based on, my lord, PW.
You are found guilty under 302 apart from other offenses.
302, my lord.
What about that SC/ST matter that you have been acquitted?
No,
Oh, yes, you are acquitted. Oh, then, or you have been found guilty. If the prosecution bring home the charges under section so and so, and so yes, 3 SC/ST Act means notice sufficient. Notice has to go.
No, my lord. Notice has not gone, my lord.
PS 65 sentence thing in upon. But found guilty location. Accused could be able to bring home the charges against so and so. Mane Kalastala petitioner under section so and so 324. Acha, what failed to acha? It's all right. What failed to bring home the charges under so and so and 3 SCSTR. So that is why SCSTR has been acquitted. This
They are acquitted from the respective acts, my lord.
failed to bring home the charge under section 31X against Kailash Swanso or Samastompai. Oh, so that is why we heard that. All right, so no notice is necessary. How many deceased persons are there in this case?
One, my lord.
One. And please come to paragraph number 2, where the prosecution case has been stated. Paragraph 2 of the judgment.
The case of prosecution is not set.
Yes. Please place it.
The case of
And use the mic properly. Yes.
case of the prosecution in nutshell is that on 25/1998, on Radhasamo Behera, here and after refer as the informant, lodge and a written report before OIC Bolonga PS, indicating there in that on that day at about 6 a.m. the villagers of village Goda Padanpur being armed with lathi, asa, ujali, and etc. enter inside the Harijan Basti and hurt, bomb, and abuse the villager of filthy language. When the villagers tried to escape with the
Lady member and children.
Again?
Lady member
and children, the accused person chased them and near Bhanapur Choko, accused Buddhanath Jana, Munna Mahanti, assault Chandramani Behera at his head by means of sword and fasa. Accused Kolas Chotra, myself, my lord. Tita Das, Kolas Patro, and others assault Kelu Behera, accused Amuli Jana, Munna Mahanti, and Potia Das assault Gundichi Behera by means of deadly weapon, accused Babuli Parida, Golok Parida, Musa Patro, Subhas Patro, and Bharat Patro, and 30 to 40 other persons, adult bomb, accused Shankar Parida and others abused the lady members in filthy language when the accused persons left the village, threatened the villagers to destroy their house by setting fire. On the basis of the aforesaid report, Bolonga PS case number 44 of 1998 was registered under section 147, 148, 294, 323, 324, 302, 149 IPC and under section 9P.
So against you, the allegation that you have assaulted Kelu Behera.
Okay.
Kelu Behera is PW1.
My lord.
Right?
Okay.
And so what injury Kelu Behera has sustained? Kelu Behera is PW1 and the doctor who examined PW1 is?
P-1, my lord.
Which who is the doctor who examined Kelu Behera? That we just want to know. It appears from the evidence of PW 12 that he collected the bedded ticket of Kelu Behera. Page. So bedded ticket of Kelu Behera was collected. So that is PW 14 is the doctor. One lacerated wound on the forehead region might have been caused by hard and blunt. Injury is simple. Another incised wound, left elbow, caused by sharp cutting weapon, simple. And one lacerated, one incised wound on the left wrist. Final opinion was not given. So that is the. So, PW1 examined by PW14. Dr. Dilip Kumar Good lacerated injury simple. Out incised wound left elbow simple. Heartlar jota opinion deyni seta hoche left wrist re ache. That is one side incised wound 1 inch into half inch. Conviction see mane jo common object kari 303 but individual assault Here also are the learning council.
My lord, pardon to mention, my lord.
Yes.
Have a glance on the para 14, my lord.
Para
On
14.
the judgment, my lord.
Yes.
Running page 39.
Wait.
Judgment page 9, running page 39.
Para 14. From
the aforesaid evidence of PW 1, 4, 5, 6, and 7, it appears PW 1 in its evidence has stated that the accused Buddhya and Munna assaulted Chandramani by means of harsa, bhujali, and sword. So also accused Kailasa Patra, Tita, and Bulu assaulted him, causing injury on his left elbow joint, left thumb, and right side head. PW 4, though not named anybody, but in his evidence has stated that Munna dealt blow to Chandramani. Buddhanath dealt a sword blow, and Kailasa Chotrai, the present petitioner, my lord, dealt sword blow. Kailas Chotrai, my lord. Kailas Chotrai dealt sword blow to Chandramani.
Perhaps that was not your initial case, because initial case was that you this man assaulted only PW1.
In this case, my lord, all are the eyewitness, my lord. In this case, PW 5, 9, and 10.
Yes, other than PW1 who has stated.
5, 9, and 10, my lord.
5.
My lord.
5 stated that
5 stated this was the
5
statement
you
of
see just the last line of that paragraph which you are placing. PW5, though not seen the assault, but in his evidence has stated that Chandramani was assaulted.
my lord. That's sword blow to
तापरे
Chandramani.
आउ की रहला बाकी रहला 4 6 7
eyewitness 5, 9, 10, my lord. In this case, eyewitness is 5, 9, and 10.
आपण पूरा paragraph 14 टा पढुचंती
आज्ञा
14 रे लिखिचंती from the evidence of PW 1 4 5 6 and 7
my lord.
पांचटा witness देइछन
आज्ञा.
So they have stated about the assault on the deceased. Name of the deceased is Chandramani or not?
Chandramani, my lord.
So
So when look back from accused Muna Manti dealing Pasa blow to my brother Chandramani. Accused Budhanath dealt sword blows to Chandramani. Accused Kailash Chodrai also dealt sword blow to Chandramani.
Let us see one another statement.
In the para 16, it was also clear, my lord. Para 16 on top, 6 line, my lord. PW 156, not only in their evidence in chief, but also in their cross-examination, it a clear term have stated that accused Buddhanath Munna and Kailash Chodrai dealt farsa and sword blow to Chandramani. Para 16 line.
You see, come this PW5, we are looking into that in paragraph 4, there is confrontation regarding the previous statement and where the has not stated about the assault made by Kailash to the deceased. With the IO.
IO is, my lord. PW 12.
PW?
12.
12. Woman is stated not there. I have examined so-and-so. During my examination, he had stated that on so-and-so had gone to in paragraph 12, we have stated that PW5 has not specifically stated that Kailash dealt blows to Chandramani by farsa. Paragraph 12 last line. This prosecution case, perhaps your initial case was something different. देखो FIR अच्छी अपने पारे
My lord.
You see in mention
My lord.
Chandramani को को माने मारिचंदी पेळु बेहरा को किए मारिचंदी पूरा स्पेसिफिक हेकिन रहिछि
My lord.
पेळु बेहरा को लिखिचंदी कैलाश छोटराय मीन्स दिस प्रेजेंट पिटिशनर
My lord.
टीटा दास एंड कैलाश पात्र हला
My lord.
आउ जो डीसी चंद्रमणि को जो माने मारिचंदी तांको नाम भी लिखाइ छि ऊपर डीसी को मारिचंदी आम ताहिर चंद्रमणि बेहरा नहीं जीवन में अच्छा लिखाइ छि कोन बुद्धनाथ जेना मुन्ना महांती खंडा और फारसारे चंद्रमणिर मुंड और देह को हाणिले so that was the initial case. See the FIR. Who has assaulted whom is by an eyewitness it has law.
ଆମ ପଛରେ ଗୋଡାଇ ଗୋଡାଇ ପିପିଲି ନିମାପଡାର ଆମ୍ଭ ସାହି ଚନ୍ଦ୍ରମଣି ବେହେରା କେଳୁ ବେହେରା ବଳଭଦ୍ରପୁର ଗ୍ରାମର ଗୁଣ୍ଡୁଚି ବେହେରାଙ୍କୁ ଜୀବନରେ ମାରିଦେବା ଉଦ୍ଦେଶ୍ୟରେ ଅମୁକ ଗ୍ରାମର ବୁଦ୍ଧନାଥ ଜେନା ମୁନା ମହାନ୍ତି ଓ ଚନ୍ଦ୍ରମଣିର ହାର୍ସାରେ ଚନ୍ଦ୍ରମଣିର ମୁଣ୍ଡ ଓ ଦେହକୁ ହାଣି ପକାଇଲେ।
କିଏ ମାରିଲେ?
2% my lord, ବୁଦ୍ଧନାଥ ଜେନା
ବୁଦ୍ଧନାଥ and
ମୁନା
ମୁନା,
ମହାନ୍ତି
right?
my lord।
ତାପରେ କେଳୁ ବେହେରା PW1 କୁ ଦେଖନ୍ତୁ। କେଳୁ ବେହେରାଙ୍କୁ
କୈଳାସ
କୈଳାସ
ଛୋଟରାୟ,
ଛୋଟରାୟ, ଟିଟା ଦାସ ଓ କୈଳାସ ପାତ୍ର ମିଶି
ହାଣି
ହାଣିଲେ।
ପକାଇଲେ my lord।
Then ଗୁଣ୍ଡୁଚି ବେହେରାଙ୍କୁ ଏଇ ମାନେ so
ଅମୁଲି
that was
ଜେନା
the case, initial case.
my lord।
Of course, with aid of 149, but that is to be taken into account at the final stage of hearing. Third, this is item number 14 CRLA number 720 of 2016, miss case number 2013 of 2016. There is an application for bail. As per the order dated 24/6/2024, the London Council for the State has produced the custody certificate of the petitioner, which is dated 3/7/2024, wherein it is mentioned that the petitioner is in judicial custody for 13 years, 4 months, and 20 days. The custody certificate is taken on record, obtained from the Superintendent Model Convict Prison Artwork, which is taken on record. The London Council State further submit that there is no criminal antecedent against the petitioner. The London Council for the petitioner submitted that the FIR story is that the petitioner assaulted Kelu Behra, PW1, along with others, and the injury report, the injury report of Kelu Behra, which has been proved by PW14. PW14 indicates that PW1 has sustained 3 injuries, out of which 2 are opined to be simple in nature, and the third one is an incised wound on the left wrist. And specific overt act has been attributed against other accused persons so far as the assault on the deceased Chandramani is concerned. However, during trial, a different story has been projected by the prosecution. And the easy for say answer. So the London Council for the State placed the paragraph number 2 paragraph upon place 14 and 16. 14 and 16 of the impugned judgment. So also the evidence of PW1 and 5. I would have
5, 9, 10 my lord।
5, 9, and 10. Considering the submission made by the Land Council for the respective party, the period of detention of the petitioner in judicial custody and around paper book ready age and nature of overt act attributed against the petitioner, and since there is no criminal antecedent against the petitioner, we are inclined to release the petitioner on bail. Shall not indulge in any criminal activity, violation of any terms, and shall entail cancellation. Yes.
Item number 15.
My lord, kindly take another matter after lunch.
Yes.
My lord, after lunch, Mr. Pandaisan and
We are just keeping it. If it is possible, we can take, otherwise it will be taken up tomorrow. Okay.
all this.
Item number 16.
Last time I was kind enough to direct the state to take instruction regarding CA as well as the attorney to produce the custody certificate.
Yes, Mrs. Sahu.
Okay,
You have to obtain instruction about not only the custody certificate, but whether there is any allegation of misutilization of liberty
yes, ma'am.
while the petitioner was on interim bail.
My lord, regarding misutilize the instruction obtained, my lord, regarding the custody certificate, my lord, tomorrow, my lord.
Okay, two more, Mr. No.
Item 8, my lord, Sanjeev. Item 8, my lord.
Yes.
Lord, item 8, my lord, one of the mistakes is there, my lord.
Yes.
One of the mistakes is there, my lord, for bail. The appellant was convicted under section 302, but he was charged under 498 and 302. The 492 he was acquitted, only 302 he was awarded the life imprisonment. Now he was inside the custody as per the statement of the IO.
Here also, we asked you to produce the custody certificate. Mrs. Sahu,
My lord, my lord.
is it available?
Okay.
Item number 8, JCRL 67 of
Good afternoon,
2040.
my lord.
As per the judgment, my lord, 27/2011 is the arrest.
Wait, he's having that fire.
जोड़ा की देखिए जोड़ा जोड़ा का दे tomorrow, my lord, जोड़ा I have already talked with the IAS.
Two things. One is that custody certificate. The other
Another
thing
thing is
is
CA, my lord.
okay. Mr.
My lord.
Yes, next matter.
Item 9, my lord, also can be taken next week.
Next week.
Item 9, my lord, I have already obtained the
File it.
my lord.
The item 9 the London Council for the State has produced the custody certificate and also the instruction, written instruction regarding criminal antecedent of the appellant, which are taken on record. Stop. Mr. Sanjeet Kumar Das, Land Council, appearing for the appellant, 6 for an adjournment till next week. This matter will be commencing from 29th July 2020.
All right.
Eta Kaliki Dokaji, Mr. Das. Yes, item number 8.
Item number 17.
Direct the state to take instruction regarding the custody certificate.
One 724. You are asked to produce the custody
My
certificate.
lord.
It,
Wait.
Madam, you see the total Mr. Das, Mr. Sahu. ଟୋଟାଲଟା କରିଦେବେ ନା ସିଏ ଯାଇଛି 14 ଦିନ ଯାଇଛି 90 ଦିନ ଯାଇଛି ଟୋଟାଲ ପିରିୟଡ ଟା କେତେ ଆପଣ କାଲକୁଲେଟ କଲେନି କଣ ପାଇଁ
ମୁଁ କରିଦଉଛି
we'll take up tomorrow ଆଚ୍ଛା ଏଟା ରଖିଥା
Item number 18.
May I please, Your Lordship? I am appearing on behalf of Mr. C.Sahoo. My Lord, the name of Mr. C.Sahoo may be reflected in the cause list in place of S.Sahoo, my Lord. There is the prisoner petition is filed, my Lord.
No, your name is there. What do you want?
In place of S.Sahoo.
Sushma Sahu's name is to be deleted. Okay. All right. Prisoner's petition has been received for engagement of Chittaranjan Sahu as his counsel. Mr. Sahu has already filed VNAMA. The name of Mrs. Sushma Sahu shall not be reflected in the cause list henceforth. Yes, what do you further want?
My Lord, it's an application for bail, my Lord.
Yes.
The offences are 302, 307 IPC, my Lord. The accused has been sentenced to life imprisonment and fine of rupees 20,000.
Please come to the paragraph number 2 of the impugned judgment where prosecution case has been narrated.
Yes, madam.
Please paste it.
Yes, madam. The prosecution case in nutshell is that on dated 11/9/2013, the informant Minaketan Tandi appeared before the IIC Narla PS and lodged a written report to the effect that on dated 10/9/2013 at about 10 p.m., the boys of Harijan Pada were dancing in front of the Ganesh Puja pendal with music. The informant was witnessing the dance with Jairam Kumar, Harsha Kumar, Manohar Nayak, and others. The uncle of the informant, Panchanan Kumar, who is the deceased, was also witnessing the dance. Due to previous enmity between Abhi Kumar and Panchanan Kumar during Nuakhai of the year 2012, the accused Abhi Kumar came with a knife and stabbed the deceased Panchanan on his belly. The informant shouted, having seen his uncle to have fallen on the ground with bleeding injury due to stabbing. The father of the informant came out of his house, having heard the shout of the informant. The accused thereafter went near the father of the informant, that is Hadibandhu Tandi, and stabbed on his belly by means of that knife. Thereafter, the informant and others shifted his uncle Panchanan Kumar and father Hadibandhu Tandi to Narla Hospital for treatment. Thereafter, as per the advice of the doctor, both the injured persons were shifted to Burla Medical College and Hospital for higher treatment. Thereafter, both the injured persons were shifted to SCB Medical College and Hospital for better treatment. While the uncle and father of the informant were struggling with death, the informant lodged the present report before the IIC Narla PS. On receipt of the report, the IIC Narla PS registered Narla PS case number 105 dated 11/9/2013 under section 341 and 307 of IPC and he took up the investigation of the case himself. During investigation of the case, the deceased Panchanan Kumar was declared dead by the doctor on dated 13/9/2013 at about 6 a.m. at SCV Medical College, Cuttack. And as such, a new section was added in this case, that is section 302 of IPC. Investigation was taken up, and on completion of investigation, as prima facie case was made out, charge sheet was submitted against the accused to stand his trial in the court of law. Subsequently, the learned JMFC Rampur committed the case to the Court of Sessions Bhavanipatna, and the learned Sessions Judge
All right.
Bhavanipatna.
So one died, that is Panchanan.
Yes, madam.
The other person, Hadibandhu,
Yes, madam.
is PW8. He has sustained grievous injuries.
Yes, madam.
And it is blow was given by means of knife.
Yes, madam.
Yes, blow on the belly.
On belly. So what is your period of detention?
My lord, it's been 10 years, 10 months since arrest.
So anything adverse, Mr. Dar?
Minor, not that is not similar, not obtained any.
Okay. Hmm. The Learned Counsel for the petitioner submits that the petitioner is in judicial custody for 10 years and 10 months.
About 10 years and 10 months.
Sure, more than 10 years, more than 10 years. The Learned Counsel for the state seeks some time to obtain the custody certificate. So also instruction regarding the criminal antecedent, if any, against the petitioner. Put of this matter, give a date. Yes.
Obliged, ma'am.
Ma'am, what is your good name? Please give it in writing.
It will come on matter.
Can you bring it on 29th?
Matter.
Yes.
29 next week.
Then it will come 5th August.
Matter.
All right.
Item number 19.
Item 19. Last occasion I already filed the custody certificate, madam. But nothing is that second copy was not filed, madam.
No, it's not necessary now. It is it is available. The scanning has been made. So if you want to argue, you can argue the matter.
I'm filing one IA for bail, madam.
Yes, that is.
IA number 1754.
What about then the 422 of 2024? How many appellants have there?
One appellant, madam.
Then why have you filed 2 bail applications?
That I already disposed of, madam. That I have.
It has not been disposed of. That is why it has come again. So let us see when the order was passed on that IA. IA number 422 of 2024. The order was passed on 15/3/2024, and the IA has not been disposed of. It was kept pending. However, you are granted interim bail for a period of 8 weeks. That is how both the IA has come. So you would not press that first one, because after availing the same, you have surrender at right time.
First surrender certificate is there.
The IA number 422 of 2024. The Learned Counsel for the appellant doesn't want to press this interim application, and accordingly, same is disposed of. IA number 1754 of 2024. The Learned Counsel for the petitioner submits that after availing the interim bail period of 8 weeks as per the order dated 15/3/2024, passed in IA number 422 of 2024, the petitioner has already surrendered. Where is your surrender certificate?
Annexed, my lord.
Annexed card.
1754
Okay, 1754 and fine. Acha. And he has annexed the surrender certificate. Yes, now you can argue.
The SCST is there, my lord. 3 SCST is there, my lord.
Notice has not been issued.
No, my lord.
Yes, my lord. Already
Let us see that.
sufficient.
Order thibo na ete 2018 ମସିହାର କେଷ୍ଟ ହେଲାଣି.
ନୋଟିସ ବି ସର୍ଭ ହେଇନି ତ ଆଇଆଇସି ରିସିଭ କରିଛି ପଠେଇଛି ରିଗାର୍ଡିଂ ସଫିସିଏଣ୍ଟ ଆସିନି ଦେଖିଦଉଛି.
ଏବେ ଲେଖା ହେଇଛି 13/12/2022 ରେ order number 3 issue notice to PW1 the victim by registered post with so and so and steps to be taken সেটা ରହିଛି. Then uh, 23/3/2023 order ଦେଖଉଛି keeping in view the fact that service of notice upon the victim has been made recently. ହେଲା ତେଣୁ none has appeared on our behalf giving one more opportunity. So notice has been served since long. So So on merit, your bail application has already been rejected, but you are granted interim bail. That very order 15/3/24, taking into account the submission made and on going through the judgment passed by the trial court as well as the deposition of the prosecution witness and so on. So, when it is seen that earlier the petitioner was granted interim bail and surrender at time, no such report, adverse report has been filed. We direct that this ones earlier. So that means your bail application was merit on considered and it was only you were granted interim bail. That first order was passed on 13/7/23, where your bail application was rejected. We are not inclined to direct so and so, and this. However, you are granted interim bail for a period of 8 weeks. So now on merit, so what is the Mrs. Sahu?
My lord.
On 15/3/2024, when he was granted interim bail.
My lord.
So what was his conduct during that period?
I will take instruction regarding that, my lord.
Because twice he was granted interim bail.
My lord.
So surrendering right.
No, surrender it's all right. You do not say that you did not surrender at right time. It appears that the last order was on 15th of March. The petitioner was granted interim bail twice for a period, each time for a period of 8 weeks. By order dated 13/7/2023 and 15/3/2024. Let the Land and Council for the state obtain instruction as to whether anything adverse has been reported against the petitioner during the period of interim bail from the concerned police station. Put up this matter. 5th
My lord.
Place this matter on 5th August 2024. Petitioner. Yes.
Item number 20.
May I please, Lord?
Yes.
Here, my lord, the appellant is in custody since, my lord, 21st February 2013, my lord. That is more than 11 years, my lord. Convicted under section C02 of IPC and sentenced for life, my lord. I have filed one bail, my lord. Miss case, that is miss case number 640 of 2018, my lord. Another miss case, that is 639 by 18, that was for condonation of delay, that has been allowed by last order, my lord.
It's all right, but
My
today it has come for consideration of your bail
bail,
application.
my lord.
So your first ground is that you are your custody period.
My lord.
So
More than 11 years.
what is the date when you are taken into custody?
I was taken to custody on, my lord, 21st February 2013, my lord.
And what is the name of the deceased?
Name of the deceased, my lord.
Videsi.
Videsi.
My lord, Videsi Naik.
Naik. Date of occurrence?
Date of occurrence, my lord, 19/2/2013.
So eyewitnesses are there.
There are two eyewitnesses.
Who are those two eyewitnesses?
PW1 and PW2, my lord.
And who is the doctor who conducted PM?
PW14.
So let us come to one eyewitness and then we'll go to the doctor.
My lord.
PW1 टाको देखो कौन से कौची अपन बना रहे.
My lord. May I please, my lord?
Come to paragraph 2.
My lord. The occurrence took place 1 year back at Brahmani Kadia near our village within 7:30 p.m. One Bijuli told me that accused Hemanta assaulted her son and he is not traceable, for which I, along with Bhakti Mukhi and Bidesi Naik, moved to search the son of Bijuli. On the way, we met the accused Hemanta, and on seeing him, deceased Bidesi asked him, "Who are you?" To that, accused Hemanta assaulted Bidesi by means of a katora, as a result of which he sustained bleeding injury on the left side of his neck, and then Bidesi succumbed to the injuries at the spot. Thereafter, accused Hemanta and then Bidesi succumbed to the injury at, thereafter accused Hemanta chased me and my brother Bhakti, for which we fled away from the spot out of fear. I could able to identify accused Hemanta easily at the spot, as it was a moonlit night. I was examined by the police and stated the aforesaid fact to police.
Okay, come to the now that doctor who conducted PM. As it appears, you gave a blow on the neck of the deceased by a sharp cutting weapon, right? Yes. That locality is called Kotora. Yes.
PW14, my lord. On 19/2/2013, I was working as assistant surgeon at CSC Chandipada. On that day at about 3:13 p.m. on police requisition, I conducted post-mortem on the person of deceased Videsi Naik, son of Gautam Naik of village Mojisahi, Teburu, PS Chandipada, district Angul, being accompanied by PK Pradhan Constable number 565, and found the following injury. 1 antemortem injury on the neck over the left side extending up to midline anterior of size 5 into 3 into 3.5 inch. The sternocleidomastoid to left side. The left carotid artery, trachea at cricoid cartilage level are lacerated as part of the injury. C3 and C4 vertebrae along with the intervertebral disc and the spinal cord at C3 C4 level is lacerated. The injury is grievous in nature, antemortem. This type of injury is possible by heavy cutting weapon.
And he has also examined that Kotora and opined that the injury is possible by such weapon.
My lord.
So direct evidence is there, corroborated by medical evidence. Only thing is that your detention period is, as you said, more than 11 years.
My lord.
Anything adverse against the petitioner, a criminal antecedent?
Regarding criminal antecedent, no such order passed by this honorable court, my lord. I will obtain, my lord.
Of course. The learned counsel for the, and of course this custody certificate also.
My lord.
The learned counsel for the petitioner, that is IA number, miss case number 640 of 2018. This is an application for bail. Learned counsel for the petitioner submitted that the petitioner is in judicial custody since 21/2/2013. Learned counsel for the state seeks some time to produce the custody certificate as well as instruction about the criminal antecedent, if any, against the petitioner. Put up this matter on week commencing from 5th August 2024. Yes.
Item number 21.
May please, my lord. In this case, the appellant has been convicted for life. He has filed a petition for interim bail. He is in custody since 8/2/2017.
Why interim bail you are seeking for?
For the marriage of her daughter. Daughter is grown up now. The wife is dead. Allegation against the husband is the convict. And no other family members.
You have killed your wife.
Allegation is that, my lord. 498 and 30.
No. Marriage date has been fixed.
No, not.
Then?
Jogad kariya pai jio grown up hai. He is more than 7 years in custody.
No, if marriage date is fixed, matter is although you are being a father,
no one is to arrange.
How can you are a convict and if you have anything to say on merit, you can argue the matter. There is no problem. But you are pressing for an interim bail. And
let it come next week. I will place on merit. I will withdraw my interim application.
All right. Peruse the prisoner's petition at flag X for engagement of Advocate Bikram Chandra Ghadei in place of Mr. Sarveshwar Behra. Mr. Ghadei, you have not filed your Bhinama?
Yes, my lord. I have filed copies with me also.
It likha hai there is a Bhinama not filed.
This is
registry baher file karchen. Mr. Ghadei submit that he has already filed Bhinama. Kebe file karchen regular date taki. On 16/10/2023. Let the Bhinama be placed on record. The name of Mr. Sarveshwar Behra and his associates shall not be reflected in the cause list henceforth. Stop. Learned counsel for the appellant seeks for an adjournment till next week. Is this matter we commencing from 29th July 2024.
Obliged.
Item number 22.
Call for a custody certificate.
You have filed this application for petition number 3. That means appellant number 3, right? So yes, Mrs. Sahoo. Two things we called for. One is that custody period, and the second is about the conduct of the appellant number 3 during the interim bail period.
My lord.
You took time on the last date,
My lord.
that is on 15/7/24. Almost 9 months reported to the file. And what about the that conduct during interim bail period?
That yet to be received, my lord.
Yes.
Yet to be received, my lord.
Moghichandi.
Again.
So,
In this case, 3 appellant is there, my lord.
no, he is pressing only for appellant number 3. His interim application has been filed for appellant number 3. So
Yes,
you are
Bhagavati
only,
Dora, my lord.
and who was granted also interim bail earlier.
My lord.
Appellant number 3 was granted interim bail and he has surrendered.
My lord.
So we want to obtain instruction. What was his conduct during that interim bail period?
I will obtain, my lord, today.
Okay.
My lord.
তারপরে S আচ্ছা দেখুন সি পড়ে যাচ্ছে item number 22, CRL number 780 of 2018, IA number 580 of 2023. This is an application for bail of appellant number 3 as per the order dated 15/7/2024. The Land Council for the state has produced the custody certificate of appellant number 3, which is dated 5/7/2024 through Senior Superintendent, Circle Jail, Barampur. Hello? And the same is taken on record. The Land Council for the state, however, seeks for an adjournment till next week to obtain instruction regarding the conduct of the appellant number 3 during.
Sorry, my lord, that was already obtained, my lord.
সেদিকে থাও তারপরে
On the CA, that was reflected, my lord, with reference to the letter and
That's all right.
my lord.
And he has also produced the report from the IIC Kotapur Police Station, Ganjam, to the effect that there is nothing adverse against the petitioner reported during his interim bail. The same is also taken on record. Yes, now what do you say?
Bail, my lord.
You were granted interim bail when last time?
Last time, my lord, 28/2/23 ରେ surrender କଲି।
25/3/23.
ଆଜ୍ଞା।
That
IA
means
500 page number 5. Annexure B order. Date 28/2/23।
So you are granted interim bail for a period of 10 weeks, my lord. Order number 17 the reflect page. It was earlier rejected in 5/8/2019. Then he was granted interim bail for a period of 10 weeks. Yes, surrender. Paper book any. Look. In view of the period in view of the period of detention of the petitioner in judicial custody, surrender certificate. Yes.
Item number 23.
Item 23, Mr. Pradeep Kumar Pradhan. Not there. Next.
Item 24.
My lord, on behalf of Pleas Kumar Mishra, permitted to withdraw.
Withdraw. Are you filing memo?
Yeah.
All right. The memo is filed by Mr. Piyush Kumar Mishra. Piyush Kumar Mishra nije sign korchanti?
Okay, sir.
Acha. Memo is filed by the Land Council for the petitioner for withdrawal of this writ petition. Accordingly, WPC is disposed of as withdrawn. Yes. Memo is taken on record.
Item 25.
My pleasure. Appellant has been convicted under section 302 of the IPC manual and sentenced to for life and a fine of rupees 5,000 for running page 35.
Single appellant.
Yes, ma'am.
Earlier bail application.
So interim bail application was rejected.
Okay. Merit it has not been considered.
Not.
Okay. So what is the date of custody?
Custody since my lord 19/1/2015.
You have been found guilty under 302.
The charge was there under 492, not guilty under 302.
Murder of the wife, huh?
Second wife, as the prosecution.
Second wife.
Yes.
So what is the cause of death?
Cause of death, burn injury.
Burn injury.
Yes.
So
case of the prosecution is that so the PW10 stated that she is the second wife of the petitioner, and on the date of occurrence, they my lord went to the Nilagiri market to snap certain photographs, and after moving, my lord, they returned, and the accused asked her to prepare the food. When she denied, the petitioner caught fire on her. But some PW2 and other witnesses have stated that when they came to the after hearing shouting, when they reached, they found that house was my lord caught fire, and the fact my lord the both the my lord petitioner and both the petitioner and the deceased both were sustained burn injuries. The petitioner also admitted in the hospital. After a month, he was discharged and admitted and arrested, my lord. He was arrested, my lord, on 19/1/2015, though he was the occurrence was 19/12/2024. For a month, he was in also, my lord, in the hospital, and the PW5, which the doctor was treating to the
but the petitioner, after he informed that he is discharged today, thereafter the IO came and arrested her, my lord, and forwarded to the custody. And other, there is also a dying declaration.
Yes. Before
my lord, PW
6, my lord.
6, my lord.
Executive magistrate.
PW 6 recorded in presence of PW 5 with the doctor. Statement of my lord,
the dying declaration has been marked as Exhibit 6. So let us see that Exhibit 6. What you have viewed.
PW2 is a direct witness to that also.
Yes, prosecution has relied, my lord. PW 1, 2.
ତୁମର ଏପରି ଅବସ୍ଥା କେମିତି ହେଲା? Executive Magistrate, ଆଜି ସନ୍ଧ୍ୟା 6টাରେ ମୁଁ ଫଟୋ ଉଠେଇବାକୁ ଆସିବାକୁ ଚାହୁଁଥିଲି, କିନ୍ତୁ ମୋର ସ୍ୱାମୀ ଶ୍ରୀ ସନାତନ ବେହେରା means the appellant ମୋତେ ଜବରଦସ୍ତ ଫଟୋ ଉଠେଇବା ପାଇଁ ନୀଳଗିରି ବଜାର କୁ ନେବାକୁ ଚାହିଁଲେ, ମୋତେ ଜବରଦସ୍ତି ଆଣିଲେ, ଘଣ୍ଟେରୁ 2 ଘଣ୍ଟା ନୀଳଗିରି ବଜାରରେ ଫଟୋ ଉଠାଇ ସାରିବା ପରେ ରହିଲି, ତାପରେ ମୋର ସ୍ୱାମୀ ମଦ ପିଇବାକୁ ଗଲା, ମଦ ପିଇ ଆସିବା ପରେ ଆମେ ଦୁହେଁ ଘରକୁ ଫେରିଲୁ, ଘରେ ରାତି 7ଟା ସମୟରେ ପହଞ୍ଚିଲୁ, ମୋତେ ଭାତ ରାନ୍ଧିବା ପାଇଁ କହିଲା, ମୁଁ କହିଲି ମୁଁ ଭାତ ରାନ୍ଧି ପାରିବି ନାହିଁ, ତାପରେ ମୋ ସ୍ୱାମୀ ମୋତେ ହାତରେ ପିଟିଲେ, ତାପରେ ମୋତେ ଘୋଷାରି ଘର ଭିତରକୁ ନେଇ କିରୋସିନ ଡବାରେ 4 ଲିଟର କିରୋସିନ ଆଣି ମୋର ଉପରେ ଢାଳିଲା ଏବଂ ତାପରେ ଦିଆସିଲି ଲ୍ୟାମ୍ପ ମୋ ଦେହରେ ନିଆଁ ଲଗେଇଦେଲା. So that is the dying declaration. You have said fair to your wife. So first wife also you killed or
No.
Natural death?
No.
But any evidence to that effect? How the first wife died?
As stated by he married second time. So, but the first wife is
No, during the subsistence of the first wife, or
he married. Yes, ma'am. Subsistence of the.
she is alive.
Yes. Having children.
So,
the conduct of the appellant, my lord, he tried to save, my lord.
Tried to save who, Rasila?
Also, 1 month, my lord, he was, my lord.
No, maybe that that 4 liters he coach in a disease 4 liter kerosene pocket, maybe some kind of struggle with the heitivo kichi niya lagithivo. But why see your wife would tell falsehood against you, and an executive magistrate has recorded the statement and other independent witnesses. They are PW?
PW1 never.
PW1 to
PW2 system.
5 to 11. No, but only the cause of some witnesses have stated that there is a quarrel regarding the preparing of the food.
1, 2, 5 ଆଉ 11 ଏମାନେ ହଉଛନ୍ତି witness to the dying declaration, right?
ଆଜ୍ଞା.
Our doctor is PW?
PW 14.
PM doctor.
Yes, ma'am.
And
PW 5 is the doctor who, my lord, in whose presence dying declaration was recorded, and he also stated that the present petitioner was under his treatment.
But the important is the witness number 11, who is the son.
Son, but he was not present.
No, mother disclosed.
The oral declaration.
On being asked, my mother disclosed that the accused burnt her by pouring kerosene as she expressed her inability to prepare the food. This is your son is telling against you.
Oral dying declaration before PW 2, 8, 10 and 11.
The deceased son says my mother. Punishing, yes.
Both are, my lord, before there is no allegation of previous torture or anything. Before the occurrence, both were, my lord, moved to the nearby market and
No,
returned.
not smoking. She was supposed to go to market. See, she had not gone smoking. That is the evidence.
Evidence.
No, evidence is that she was not willing to go and she was forced to go to market. That is the evidence. She was not going to have the photograph.
The cause of death is also burn injury.
72%.
assault ମଧ୍ୟ କରିଥିଲା assault କଲା ପରେ 4 ଲିଟର କିରୋସିନ ପୁରା ଢାଳିକିନି ତାକୁ ନିଆଁ ଲଗେଇଛି.
The influence of liquor.
Heard the learned and counsel for the petitioner, learned counsel for the state. The learned and counsel for the petitioner submitted that the petitioner is in judicial custody since 19/1/2015, and the case is based on the dying declaration, oral dying declaration as well as recorded dying declaration, and the material available on record indicates that the petitioner himself sustained burn injury and was hospitalized for about a month, and thereafter he was taken into judicial custody. And in all probability, the petitioner was trying to rescue the deceased, and that is how he sustained burn injury. It is further submitted that there are good chances of success in the appeal and balance of convenience is in his favor and no chance of early hearing of the appeal. Therefore, the bail application may be favorably considered. Learned counsel for the state, on the other hand, opposed the prayer for bail, placed the evidence of PW6, the executive magistrate who has recorded the dying declaration. So also the evidence of the witnesses like PWs 1, 2, 5, and 11 who have stated about the oral dying declaration being made by the deceased. Learned counsel for the state also placed the evidence of PW 14, the doctor who conducted post-mortem examination and opined that the cause of death was on account of complication arising out of burn injuries. And the deceased had sustained burn injury to 72 to 75% of the total body surface area. It appears from the evidence on record that the deceased was the second wife of the petitioner, and during the subsistence of marriage, the first wife was also having children. This incident took place. After going through the evidence on record placed by the learned counsel for both the parties and the nature and gravity of the accusation, and particularly the post-mortem report finding, we are not inclined to release the petition on bail stands rejected.
Item number 26.
My lord, that time will also call for report from whether it's sound or not.
We called for some report.
Yes.
It appears that the appellant was granted interim bail for a period of 8 weeks from the date of his actual release from the custody as for order dated so on. So, learned counsel for the appellant submits that he has instructions that the appellant has surrendered before the learned trial court after appealing so on so, but he is not having the surrender certificate. Okay. So the report is the convict was released on bail for a period of so and so, and after expiry of the interim bail period, he surrendered. Okay. So that is What do you want now?
Paper bail lordships.
So the order in which you are granted interim bail, that is
Bar 2.
yes,
12 to 2000 notice.
on the ground that the appellant was suffering from serious diseases, and his treatment is required to be done in an advanced hospital. So that is how you are granted bail, interim bail, for a period of 8 weeks. Now, what ground you have taken for? Your bail application has been rejected on merit. Huh?
Bail application is not treated lordships.
Are you sure that it has not been rejected on, never been rejected on merit? And you only file an interim bail application?
Yes, sir. Where is pending lordships?
Okay, no, we just want to. Okay, so main bail application is pending. Oh, that is of the year 2019. So, what is your conviction and what is the sentence imposed?
Conviction by Lord 300 to 364 IPC and
Hmm.
life and fine of 5,000 rupees, my Lord.
So, it's a case where you kidnapped someone and then committed murder. Is it a case of any direct evidence or circumstantial? Circumstantial evidence.
That's in theory.
So, last seen deposed by whom?
PW 2, 3, 4, 8, 9.
2, 3, 4,
8, 9,
8,
11.
9.
11, 12.
11.
11, 12.
So both of you are seen going together.
Assaulting and
Assault and
dragging the,
Towards the
this
jungle.
is matter.
Deceased is a lady.
No, my Lord.
And I can have a glance on PW 8 matter.
PW 8 also. PW 8 is Narano Hansda. I saw the accused dragging the deceased from Lunikia Sahi towards nearby jungle. And while doing so, he was assaulting him. The victim was shouting, Rakhyakar, out of here, okay. Then his dead body was recovered from that jungle or what?
Jungle, my Lord.
Decomposed state. So this occurrence took place when and when the dead body was recovered?
31 occurrence.
Date of occurrence was 31/12/2013 in the afternoon.
16 days after, he was dead body was recovered, my Lord.
16 days after.
Yes, my Lord.
What is the cause of death as per the PM report?
Cause of death is, my Lord, due to shock and hemorrhage.
PW.
PW 6, my Lord.
What is your custody date?
Custody, my lord. 16th January 2014.
You are never released on
No, my lord.
bail.
Except in tribunal.
Okay. 14 କହିଲେ ପରା?
ଆଜ୍ଞା।
IA number 466 of 2019. There is an application for bail. The London Counsel for the petitioner submitted that the petitioner was taken into judicial custody on 16/1/2014, and he was granted interim bail for a period of 8 weeks as per order dated 12/2/2024. And after availing the same, he surrendered at right time. And the London Council has also filed the surrender certificate. You have filed.
My lord, your instruction confirmed.
Acha, status. Yes, surrender at right time. The status report dated 12/7/2024 submitted by the London Trial Court also surrendered the indicate that the petitioner surrendered at right time. Stop. It is argued by the London Counsel for the petitioner that there is no direct evidence in the case. Case is based on circumstantial evidence, and the main circumstance is the last scene of the petitioner in the company of the deceased, which is deposed to by number of witnesses. And the petitioner was seen dragging the deceased towards the jungle. However, the dead body was recovered from inside the jungle 16 days after the date of occurrence, and therefore the evidence relating to last scene is not very clinching. And the doctor who conducted post-mortem examination, that is PW6, has also marked that the body was in advanced stage of putrefaction, and he has opined the cause of death due to shock and hemorrhage due to injury to the brain. The London Council further submits that the paper book has not been prepared, and therefore the bail application of the petitioner may be favorably considered. London Council for the state opposed the prayer for bail and placed the evidence of the doctors who also the witnesses to the last scene. After hearing the London Council for the respective parties, the nature of evidence adduced during trial, and particularly the evidence of the doctor, bracketed PW6, while not inclining to release the petitioner on bail on merit, but taking into account the ratio let down in the case of Letty versus Swanso. And since the petitioner has complied with the terms and conditions of the earlier interim bail order granted by this court, we are inclined to release the petitioner on interim bail for a period of 3 months. That report has to be called for from the IIC regarding his conduct while on interim bail, and matter to be placed after 3 months. He has to produce the surrender certificate. Yes.
Item number 27.
My lord, kindly pass over the matter on the behalf of Mr. D. Ponda.
Today you want to move or any other day?
Sir, today.
Today. All right, pass over.
Thank you, sir.
Item number 28.
Please, Your Lordship. Last occasion, Your Lordship, Director my letter friend to obtain the CA, Your Lordship.
Nothing adverse against the petitioner. You have been found guilty under section
302.
302.
My lord.
What is the name of the deceased?
Deceased.
Abhimanyu Sahu.
Abhimanyu Sahu, Your Lordship.
As it appears from the impugned judgment, 3 persons were facing trial.
Yes, sir.
What happened to the other 2?
They are also convicted and
Separate appeal has been filed.
yes, separate appeal.
Okay. In this criminal appeal, there is only one appellant.
In this, only one appellant,
Okay.
Kalyan.
Now, is there any eyewitness to the occurrence?
My lord, next occasion,
2, 3, 4, 6.
Just a minute.
2, 3, 4, and 6.
PW 2, 3, 4, and 6. Okay.
PW 13 is the doctor.
Doctor is PW 13, PM doctor. So, please come to one eyewitness, PW 2, please.
My
95 page. There's 95.
PW2 is Nirupama Sahu.
My lord, the wife of the.
Yes.
My lord. I am the informant in this case, Your Lordship. I am blessing the.
Yes.
I knew the deceased Abhimanyu Sahu was my elder brother. I know all the good persons of this case facing the trial, and they are the resident of village Rupali. Two. My brother Abhimanyu died 1 year back. That is on the following day of last Rathayatra. Myself, my husband, Ashoka, and brother deceased Abhimanyu had opened a tiffin shop on the Beda Bododando of Hindol Gundichapada. On the day of Rathayatra, around evening, all the 4 accused persons facing this trial came to our shop for taking tiffin. When I demanded money, they abused me in obscene language. When my brother Abhimanyu and husband Ashok, who were present in the shop, raised objection, the accused persons abused them and threatened to set them right and went away. On the same day, at around 9 p.m., we closed the shop and started for our home. Whereas Abhimanyu and my cousin Subhaso were walking ahead, me and Ashok were walking behind them. Near the Gundicha Mandap, suddenly Bullu, Kesava, Prasanto, and Kalia, resident of village Rupali, surrounded Abhimanyu, accused Kalia as having a lathi in his hand, and with that lathi, he assaulted Abhimanyu on the head, as a result of which he sustained bleeding injury and fell down. Thereafter, Kesava, Prasanto, and Bullu assaulted Abhimanyu and by fist blows and kicks, and when we shouted, they fled away towards village Rupali. We immediately took Abhimanyu to Hindal Hospital, being referred by the doctor. We took him to Angul Hospital, where the doctor of Hon'Ble Hospital advised to take the injured to Cuttack Medical while undergoing treatment at Cuttack. On the next day of occurrence, around 1:30 p.m., my brother Abhimanyu died. 7. I then lodged a written report at a Hindol police station. One Dilip Behra, the councillor of our ward, on my request and as per my dictation.
So it's all right. So you have assaulted the deceased on the head by means of a lathi, and as a result of which he sustained injury, he was shifted to the hospital, and on the next day he died at Cuttack, right? Okay. So now you come to the doctor who conducted post-mortem examination.
My lord, I'm blessing your lordship. On 26/6/2017, I was working as senior resident, Department of Forensic Medicine, SCB Medical College, Cuttack. On the same day, on police requisition, I conducted a PM examination over the dead body of Abhimanyu Sahoo, son of Gadadhar Sahoo of village Inda, Patna district, Dhankanal. On examination, I found external injury as mentioned below. 1. Stitched lacerated wound of length 6 cm with 5 numbers of black surgical structure present over the right.
Surgical sutures.
Surgical
Sutures.
Sutures present over the right peritoneal eminence with surrounding scalp head 7. 2. Right side black eye. 3. On discussion, I found under surface of scalp was contusted over right peritoneal region under external injury number 1. Right temporal muscles were contusted. Skull was intact. There was extradural hemorrhage of size 12 cm into 8 cm into 3 cm present over the right temporal area with the compression of brain. Left temporal and right frontal lobes were constricted and lacerated. Intracerebral hemorrhage was present in left temporal and left frontal lobes. Brainstem hemorrhage was present in midbrain and pons.
Come to the next paragraph. That it's a craniocerebral injury and their complication.
My lord.
So you have given a blow with a lathi on the head.
Sudden of great provocation.
What is provocation? What is provocation?
You know,
there is preparation, not provocation. Because they left this spot. After some time, they have come and directly they hit. The altercation was in the shop at a particular time. Then they left with a caution to see them, and they have come with preparation and they.
But my lord,
Since when you are in custody?
26/7/2015.
22/7/2015.
26/6/2017. 26.
26/7.
26/7/2017.
17 ହେଲେ 7 years ବି ହଉନି।
ବାହାରେ ବି ପଡିଲାଣି ହଉଛ। ବାହାରେ ପଡିଲାଣି କାଳେ ସରି
କଣଟା କଣ ହେଲା?
କେଶବ ନାୟକ।
No. You see, you are the only assailant so far as the head is concerned, and you dealt that blow, and you have not completed even 7 years.
Criminal antecedent nahi. Any stringent condition they don't. Age time.
The learned counsel for the state, as per the order dated 15/7, no, not 15/7, that is as per the order dated 9/7/24, has produced the written instruction received from IIC Hindor Police Station dated 27/20/24, from which it appears that nothing adverse was found against the petitioner. The written instruction was taken on record. The learned counsel for the petitioner submitted that the petitioner was taken into judicial custody on 26/7/2017. And as per the eyewitnesses account of PWs 2, 3, 4, and 6, the petitioner stated to have dealt a blow on the head of the deceased by lathi. Deceased na likhi diyantu Abhimanyu Sahu. And the doctor bracketed PW13 who conducted post-mortem examination has noticed the injuries on the head and opined that the cause of death was due to craniocerebral injury and its complication. He further submits that the materials available on record indicates that under grave and sudden provocation, the petitioner assaulted the deceased with a lathi, and since paper book has not been prepared, there is no chance of early hearing, and therefore the bail application may be favorably considered. Learned counsel for the state, on the other hand, opposed the prayer for bail and placing the evidence of the eyewitnesses stated that there is no material available on record relating to any grave and sudden provocation. Rather, the material on record indicates that after the first incident, the appellant came prepared to the spot holding a lathi and assaulted on the vital part of the body of the deceased, that is head, which resulted in the death of the deceased. Considering the submission made by the learned counsel for the respective parties, the nature of evidence adduced by the eyewitnesses coupled with the post-mortem report finding, we are not inclined to release the petitioner on bail stands rejected. Yes.
Can item 27 be taken? Just
yes, sir.
Item 27, my lord. Some of the witness, my lord, we do 1 and 2. The deposition copies are not legible. So let me get it, my lord, because that basically.
Deposition copy Mr. Panda has supplied.
My lord. Yes, my lord.
Lords, in fact, it is totally illegible so far as I am also concerned. I have to read it out with much difficulty.
Yes, why it has to happen? Whether the original record sheet.
Certified copy that has become.
Original record देखिले एक number और 2 number साखी रो deposition पढ़ी हो जी
एक नंबर तो होने 2 नंबर
नहीं
टिके चलो जी
ना पढ़ो total
1 and 2 both are not
देखिए पढ़ी हो नहीं এটা তো অরিজিনাল না এটা বলে জেরক্সটা হ্যাঁ অরিজিনালটা কি তার বেটার ছিল তারা ସେମାନେ ବି ପଠଉନାହାନ୍ତି ଲୋକ print no let the original LCR be called Mr. Panda, that is also the same type the total dekha jauni ek number 2 number we are calling for that original LCR, right? That would be better. And lekhandu Mr. Devasis Panda, so also Mr. Das and counsel appearing for the state submitted that the evidence of PW 1 and 2 are not legible. We also found that it is not legible. Let the original trial court record be called for, and the file be placed before the registered judicial. Will send immediate email to the learned trial court call for the, and the same be made available by good date दिजंतु अच्छा ठीक है matter to be listed in the week commencing from 5th and that trial court record should reach on or before 31st of July 2024. Hello? Okay.
The parties may take copies from the
after receipt of the original trial court record, the deposition copies of PW 1 and 2 is supplied to the learning counsel for the appellants, also to the learning counsel for the state. Hello? Okay. And this matter is to come, no, it is single matter, na? Acha, ठीक है, okay. ठीक है.
Item number 29.
29 members. Also, other co-accused persons have been released on bail by Honorable High Court.
29, I have assigned special assignment, this case, my lord. 29, my lord. Yesterday I got the file, my lord. What happened? I have obtained instructions super one of the petitioner concerned, my lord.
So, my
lord, last of them 15/7/24, he received director to obtain the CA and my lord the custody certificate, my lord.
Yeah.
So far, my lord, the one CRLA 780/2019, my lord, CRLA. I have, my lord, got the instruction, but so far my lord, the CRLA 649/19, my lord, I have not got the instruction as because my lord, so far the custody certificate is concerned, my lord, he has been transferred to another jail, my lord. For that, my lord, another week may be given.
I mean, custody, my lord, there is no
able to, my lord,
dispute on
obtain the complete instruction, my lord.
in which custody certificate has been?
Go.
I mean, custody.
We are in custody more than 1 week, my lord. Next week.
Mr. Just a minute, Mr. This you have received in CRLA number 780 of 2019, custody certificate is available.
My lord.
But so far as 649 is concerned, you have to obtain it.
My
right? And then the other order, any other order was passed? No, that is only the order.
One date, 15/7, 1 week time. So that I
May
completely.
Yes.
The thing is that 5 persons were 5 accused persons. 3 have got released on bail mailers by Honorable High Court since that is 11th April 2023. I am in custody. There is no dispute on that. Secondly, mailers, only one allegation during my release, interim release, and that in this case also I got my bail mailers.
No, it's you mean to say that apart from this custody, claim of parity is to be taken into account. Some of the co-accused persons have been released on bail. So
No main, no others.
These petitions, my lord, the case based on circumstantial evidence, my lord. Circumstantial evidence. These petitions, my lord, they are the contact killer, my lord. They have taken supari from the co-accused and my lord asserted. That is the allegation, my lord.
We are not hearing today on merit. We just because he's praying for time till next week.
Next week,
to for obtaining that custody certificate.
Both.
By the way, you have received the bail order copies of the co-accused person. So you examine the claim of parity. If you say that they are not
coming under the parity, my lord.
All right, we'll see. We'll see that. Had the learning counsel for the state submitted that he has received the custody certificate in CRLA number 780 of 2019. However, though instruction has been sought for obtaining the custody certificate of the appellant Santosh Maharana. He is the single appellant in that appeal. Okay. In CRLA number 649 of 2019, but the same is yet to be received and the matter may be taken off next week. The learning counsel for the appellants have already supplied the bail order copies of the co-accused persons and let the learning counsel for the state examine the claim of parity. Mr. H.S. Mishra, learning counsel for the informant, is present. Put up this matter in the week commencing from 29th July 2024 with swan. So it is 780 order tag or deve. SC was 649 of 2019. The learning counsel for the states shall also obtain instruction in the meantime regarding criminal antecedent, if any, against the petitioner against the appellants in both the appeals, criminal appeals. So it will come on 29. Yes.
Madam, be pleased to fix it on 29.
29.
Will you
That week there will be there. Any date it will be convenient to the party.
We may be permitted at least to move it on 29th so that it can, if it not be taken up, then it will be taken up on 30th.
No, ये जो बर्तमान जो ऑर्डर्स लिस्ट आसुची सेटा एंटायर वीक ପାଇଁ ରହୁଛି ତେଣୁ ଯାହାର ଯଦି ମନେକର 29th ରେ ଆପଣଙ୍କର ଅସୁବିଧା ଅଛି you can we are calling it we are not adjourning unless yeah.
Item number 30.
Please, Lord, sir. Yes, Section 198A and 302 matter, the life conviction matter, and fine 10,000. In 1910, 2015 to still today, the petition is custody matter.
1910, 2015.
15. Still custody. No bail. No direct evidence matter. Only presumption based on the yes and to.
You are the husband.
I am the husband. The offense on the 198A.
What is the name of the deceased?
Sunita.
Sunita.
Sunita Naik.
And what is the cause of death?
Burn injury and kerosene.
So what are the materials available on record?
Mother. No dying declaration, mother. Only presumption there is a kerosene 5-liter kerosene jar in the house.
So you are staying with the deceased in a particular house or in a particular room. So how many years after the marriage this incident?
7 years. 7 years, madam.
7 years after. Have you? Yes.
PW2. The doctor recorded the dying declaration exhibit 2.
Yes. Mr. Counsel, PW2, Mr. Das says that he has recorded the dying declaration. Why you said that?
That is exhibit 2.
No. Dying declaration, but sorry, madam. Dying declaration, but is not clearly mentioned. You receive go to page 4.
Her dying declaration was recorded in questionnaire form in presence of staff nurse Miss Anita Mishra.
Sorry, madam.
And the elder brother
exhibit 2 is the that dying declaration.
Yes,
exhibit of our
but he is not saying anything, madam. Sorry, madam.
No, that's a different thing. But why are you?
Sorry, madam. Sorry, madam.
Don't try to make such a statement.
Actual
aspect रे wrong statement କୁହନ୍ତୁନି. ତୁମର ନାମ କଣ? ସୁନିତା ନାୟକ. ତୁମ ସ୍ୱାମୀଙ୍କର ନାମ କଣ? ମୁରଲୀ ନାୟକ. ତୁମର ବୟସ କେତେ? 30 ବର୍ଷ. ତୁମର ପିଲା କେତୋଟି? 2ଟି ଝିଅ, ଗୋଟିଏ 6 ବର୍ଷ ଓ ଗୋଟିଏ 1.5 ବର୍ଷ. ତୁମର ଘର କେଉଁଠି? କତଡ଼ା. ତୁମ ସାଙ୍ଗରେ କିଏ ଆସିଛନ୍ତି? ଶାଶୁ ଓ ଦେଢଶୁର. ତୁମକୁ କିଏ ପୋଡ଼ିଲା? ମୋର ସ୍ୱାମୀ ଗୋଟିଏ ଝିଅକୁ ଭଲ ପାଉଅଛି, ସେଥିପାଇଁ ସବୁବେଳେ କଳି ହୁଏ। ଆଜି ସେ ମୋବାଇଲରେ ଗୋଟେ ଝିଅ ଫଟୋ ଦେଖୁଥିଲା। ମୁଁ କହିବାରୁ ସେ ମୋତେ ଘରେ ପୁରାଇ ପାଟିରେ କନା ଦେଇ କିରୋସିନ ଢାଳିଦେଲା ଓ ନିଆଁ ଲଗେଇଦେଲା। ଘରେ ନିଆଁ ଲାଗିବାର ଦେଖି ମୋର ଦେଢଶୁର ମୋର 2ଟି ପିଲାକୁ ନେଇଗଲେ ଏବଂ ମୋର ସ୍ୱାମୀ ନିଆଁ ଲଗାଇ ଦେଇ ପଳାଇଗଲା। ତୁମେ ଦସ୍ତଖତ କରି ଜାଣିଛ କି? ମୁଁ ଦସ୍ତଖତ ଜାଣିଛି, ହେଲେ କରିପାରିବି ନାହିଁ, ମୋ ଟିପ ଚିହ୍ନ ଦେବି। So the patient was conscious when the dying declaration was taken. The patient could not sign due to the burn injuries to the finger. The declaration was taken in presence of the doctor, staff nurse, mother-in-law of the patient, and brother of the husband. So your mother was also present.
Yes, ma'am.
Right? Yes. And she has signed the so ଦେଢଶୁର ସାଇନ୍ କରିଛି। ଆପଣଙ୍କ ଫ୍ୟାମିଲି ମେମ୍ବରଙ୍କ ପ୍ରେଜେନ୍ସରେ ତାର ଷ୍ଟେଟ୍ ଅଫ୍ ମାଇଣ୍ଡ ରେକର୍ଡ କରାଯାଇ ଗଲା ଏବଂ ସେ ଡାଇଂ ଡିକ୍ଲାରେସନ ଦେଲା। ଆପଣଙ୍କୁ ଇମ୍ପ୍ଲିକେଟ କରୁଛନ୍ତି। ଆପଣ
Para 4 of the doctor, the cross examination, madam.
Para 4, Dr. PW2. Let us see.
It is not a fact, madam. It is not a fact. If a person having 80% burn injury comes from a distance place for more than 60 kilometers, he cannot give answer. The victim being accompanied with her mother-in-law
and elder brother-in-law had come to hospital at the time of recording of the dying declaration of the victim. Both her mother-in-law and brother-in-law were present there. It is not necessary to record in the dying declaration of a person what treatment has been given to her. So I have not mentioned the same in dying declaration. It is not a fact that the statement by Exhibit 2 is not a voluntary statement of the victim, and such a statement has been given by her by her being pressurized and tortured by the relative.
Tutored by her relative.
Tutored by her
ये relatives ରହିଲା ଆପଣଙ୍କ ନିଜ ମା ଭାଇ ପରା ରହିଲେ ବଡ ଭାଇ ସେଇମାନଙ୍କ ପ୍ରେଜେନ୍ସ ରେ ଷ୍ଟେଟମେଣ୍ଟ ଟା ରେକର୍ଡ ହେଲା ଆଉ ରିଲେଟିଭ୍ସ କଣ ଡିସିଜ୍ଡ ସାଇଡ ର କିଏ ଫ୍ୟାମିଲି ତା ପ୍ୟାଟର୍ନାଲ ସାଇଡ ଫ୍ୟାମିଲି ମେମ୍ବର ଅଛନ୍ତି କି ଆପଣଙ୍କ ନିଜ ମା ଭାଇ ସେମାନଙ୍କ ପ୍ରେଜେନ୍ସ ରେ ଡକ୍ଟର ରେକର୍ଡ କରୁଛନ୍ତି ତ ଟ୍ୟୁଟର କଣ ହେଲା ତା ଦେହରେ
What is there in your favor?
going to my letter some PW
ଆପଣ କହିଲେ ନା paragraph 4 ଟା ଦେଖନ୍ତୁ we were under an impression that perhaps something is there in your favor. So which is the line in this paragraph 4 which favors you?
I myself to admit the victim in emergency ward without seeing the admission register. I cannot say the OPD number. It is a fact that the below of the LTI of the victim Exhibit 2, 1 or 2, I have not made a attention, but I have given endorsement that LTI belongs to victim Sunita Naik. It is a fact that in the first page of below, the LTI such an endorsement has not given by me. Your Lordship, also the PW20, the PW20, the IO. On
yes
PW20 माला
कौन टा प्लेस कौन टा पू लाइन प्लेस करिए
माला that 14 days matter he is in matter 14 days in the medical matter. So let's go to the first para also. I have all para also. No,
initially the case was registered under 498-307. So she was taken to the hospital. So she struggled with her life. Ultimately, after 14 days, while undergoing treatment, died. And it's a case of burn injury. Dying declaration is there. So what is your submission? Whether after 14 days, if somebody dies, it would not be a case under 302?
Yes. What malady cost to 9 years matter? 9 years is already cost. So
that is not.
But
all the contradictions that you have brought through the witness has been denied by the IO. It is a fact. It is a fact. He has stated. All the witnesses.
PW10 also matter kada. PW10 matter.
PW10 कौन कौची?
सेते से oral diagnosis ता पाखे जेते से rescue करला from the burn malord. She has stated matter.
From the place of burn, he shifted
I removed both the children and myself and my mother removed Sunita to the roadside. She told that accused morally tying her poured kerosene and set fire.
So you see, your marriage took place 7 years back. You are having 2 children. You are having some affair with another girl. The deceased opposed, and on that day also found in that position, he opposed, and then you did all these things.
PW9 the PW9 was pharmacy. He also declined cross-examination. He will decline the pharmacy matter. PW19. 19. Sorry, 19.
No, PW9 has not supported the prosecution case for which he has been declared hostile by the prosecution. How do you overcome the evidence of this PW2 and
your own
brother, mother, in whose presence it has been recorded?
1 week after my letter.
The wastage of time. But coming prepared and after reading the mentality of the judges you should not seek for an adjournment.
1 week, 9 years custody, so that 1 week time. I also deeply go to the
move bail application, move.
No, one
You
bail
must be prepared to face the.
not
so,
personal.
Hmm?
One bail application I have not personal because I'm filed for interim bail. So the mother died, so that time he's already.
How much time you consumed today? And if we adjourn this matter after hearing, is it not a wastage of time, valuable time of the court? And why we adjourn? If you have got some other points, tell us, we are ready to hear. But after seeing this, we are going to pass the order. But you perhaps read the mind of the court and then you are seeking for an adjournment. If you have some other ground, tell that it's all right.
Or you renew anytime.
Can renew the prayer afterwards. Or the learned counsel for the petitioner and counsel for the state. The learned counsel for the petitioner submits that the petitioner is the husband of the deceased Sunita Naik, and he was taken into judicial custody on 19/10/2015. And the case is based on circumstantial evidence. And the main circumstance is the dying declaration, which is stated to have been made before PW2, the doctor who treated the deceased in the hospital. The learned counsel further submits that the dying declaration appears to be a tutored one, and there are good chances of success in the appeal, and balance of convenience is in his favor, and there is no likelihood of the appeal being taken up for early hearing, as paper book has not been prepared, and therefore the bail application may be favorably considered. Learned counsel for the state, on the other hand, opposed the prayer for bail and placed the evidence of PW2, who recorded the dying declaration and proved the same as Exhibit 2. And it seems that in the presence of the mother and elder brother of the petitioner, the dying declaration was recorded. The learned counsel for the state further submits that even PW10, who rushed to the spot and found the deceased lying in a burnt condition, has also stated that the deceased implicated the petitioner to have poured kerosene on her and set her fire. The doctor, PM doctor, PM doctor.
PM doctor told PM doctor sir. Judgment last page option.
No, the postmortem report has not been marked as an exhibit in this case. Then who has proved it? Postmortem report to achhi na? Exhibit mark each exhibit. I owe the 7. Exhibit 7.
7.
Like the postmortem report indicates that the deceased died on account of burn injury and its complication, marked as exhibit 7 lagla, and there was 100% burn injury over the total body surface. Learned counsel further submits that the petitioners married the deceased 7 years prior to the occurrence, and they were having blessed with 2 children, and the dying declaration marked as exhibit kete se na 2 indicates that since there was extramarital relationship of the petitioner with a girl which was opposed to by the deceased, deceased, the petitioner poured kerosene on the deceased and set her on fire. Considering the submission made by the London Council for the respective parties, the nature and gravity of the accusation, the dying declaration recorded by PW2, and so also the post-mortem report finding, we are not inclined to release the petitioner on bail, stands rejected.
After lunch,
after lunch. Written.
I would like to. So, item number 23 is listed in the weekly list as item number 53.
Which is that item?
Item number, my lord, 53. Admission. Weekly. This item may not be reached, my lord.
No, it's this Cuttack problem, na?
No, interstate, my lord. For that reason, the Honorable Chief Justice has assigned this matter to this Honorable bench.
We'll see. We are going with this serially. We are today. It is not possible because there are number of orders matters, bail matters we are hearing.
Only one submission I would like to. Date may be fixed so that the matter can be.
It is there in the list. We may just touch it this week. We can see that. Okay. You please wait. We'll go serially.
My lord.
Okay.
And State Council may be directed to be ready.
Oh, yes,
old matter. Obligement.
Yes.
Item number 31.
Appellant convicted 1/2017 under section 302 IPC.
What is the date of custody?
1/2017.
Na? So under section
302 IPC.
302.
My lord.
So please come to the prosecution case, paragraph 2 of the judgment.
My lord. The sole accused Nityananda Mukhi, the brief fact, the prosecution case are that the deceased is the wife of the accused. The informant was his son. The accused was always suspected his character. The deceased Kalpana and their conjugal life was not peaceful. The accused also used to assault the deceased regularly, suspecting her character. When the torture on the deceased became unbearable. Unbearable, sir. She left the matrimonial house. The informant, who is the son of the accused, after much persuasion, brought her back to the maternal house just 15 days before incident. On 31/12/2016, there was a quarrel between the deceased and accused. On the 1/1/2017, at about 1:30 p.m., while he and his mother were repairing dumps, and his father reached there holding the tangia, and all on sudden gave 3 to 4 blows to the neck of his mother, including several bleeding injuries. The deceased died at the spot instantly. After assaulting the deceased, the accused left the spot. Thereafter, the Munnamukhi, the son of the accused, lodged a written report before the ISC Jarpada PS.
So, who is your son who has been is an eyewitness?
PW2.
PW2.
Mila. Munnamukhi.
Munnamukhi.
Mila.
He has supported the prosecution case.
Munnamukhi supported the prosecution case.
That means he has stated against you, being the son, he has stated against you.
Mila.
So you have given 3 to 4 blows with tangia on the neck.
Yes, ma'am.
So what is the PM report?
PM report also stated
PW7 is the doctor.
PW7 is the doctor.
PW7.
My lord. PW7 doctor also stated one report only. On AK-2017, I was in my present post on that day at about 10:30 a.m. My lord, occurrence also 1:30 p.m. Doctor Kuchit, 10:30. On police request, I concluded PM the examination over the dead body of the Kalpana Mukhi, developer Nityananda Mukhi of village Jerang district Deorisai under Jarpada PS, female aged about 45 years, found one inside wounded, only one inside wounded, measuring 6 on the left neck, extend from strength mustard muscle to third cartridge with extensive homeritis and lacquers of
କଣ ପଢୁଛନ୍ତି?
sir ଚଷମାଟା ଆଣିଲେ ତ
ଚଷମା ନ ପଢିଲେ ତାହେଲେ କି ୱାର୍ଡ ଗୁଡା ଯାହା ପାରି ତାହା ପଢିଲେ ହବ?
ଟିକେ ସେଇଟା ଛାଡି ଦେଇ
Don't forget, you are an advocate of the High Court, and this proceeding is being live streamed. Okay, everybody, not only the students, the judicial officers, everybody is watching it. Even if not live, afterwards it is watching. So you should be careful enough, right?
Sorry, ma'am.
And let us say in this case that the evidence of PW2 to the extent that 3 to 4 blows was given is not getting corroboration from the, but what about that, let us say one blow on the vital part of the body like neck,
yes,
and the impact it has caused on the deceased as per the evidence of PW7, and it has affected all the entire area of the neck. Major veins have been affected, and that is how he made instantaneous death. So,
doctor examines only one.
That is what exactly I'm telling you. You may advance an argument during trial, during the hearing of the the evidence is that 3 to 4 blows has been given, but so and so. In fact, you have not put any question to the doctor in that respect. That suppose 3 to 4 blows would have been given, more with this sharp cutting weapon, more number injuries would have been expected on this one. So that you have not put any question. Whatever it may be, why bail is to be granted when you have killed your wife?
My lord, PW2 in his cross examination, para
PW2, yes,
informant in his cross examination, para 4, he also stated the contents executive was not read over the explained to me prior to such incident. There is no report before the police about the frequent assault on my mother by my father.
ଘରୋଇ ଭିତରେ ବାପା ଆପଣଙ୍କର ସେ ୱିଟନେସ ର ବାପା ତା ମାକୁ ମାରୁଥିଲା। ତ
କିନ୍ତୁ ସେ ଯୋଉ ମାରୁଥିଲେ ସେଥିରେ ସେ ତାକୁ କୌଣସି
ସବୁ ଜିନିଷ କଣ ଘରୋଇ ଇଏ ଗୁଡାକ ସବୁ ରିପୋର୍ଟ ହେଇଯାଏ, ଆଉ ରିପୋର୍ଟ ହେଲେ ବିଶ୍ୱାସ କରାଯିବ, ଆଉ ଓରାଲ ଏଭିଡେନ୍ସ ଯଦି ଆକ୍ସେପ୍ଟେବୁଲ ହବ ତାକୁ ରିପୋର୍ଟ ନ ହେଇଛି ବୋଲି ଡିସକାର୍ଡ କରିଦିଆଯିବ। ଘରୋଇ କଳି ଗୁଡାକ ହୁଏ ଯୋଉ ସ୍ୱାମୀ ସ୍ତ୍ରୀ ମାରନ୍ତି ମାରେ, ଯୋଉଟା କଣ ସବୁ ରିପୋର୍ଟ ହୁଏ? ଘର କଥା ପଦାରେ ପଡିଯିବ ବୋଲି ବହୁ ଜିନିଷ କହନ୍ତି, ଯୋଉ ଘର କରିଥିଲେ ପଥର ପଡିଲେ ସହି, ବହୁ ଜିନିଷ ଚାପି ହେଇକିନି ରହିଯାଆନ୍ତି, କାରଣ ଭବିଷ୍ୟତରେ ହୁଏତ ପରିସ୍ଥିତି ଚେଞ୍ଜ ହେଇଯିବ, ତେଣୁ ଏମିତି ହୁଏ ମଧ୍ୟ।
ଅନ୍ୟ ୱିଟନେସ୍ ବି
ତେଣୁ କାହିଁକି ରିପୋର୍ଟଟା ଏଫଆଇଆର ଟା ନ ହେଇଛି ବୋଲି କଣ ପାଇଁ ତାକୁ ଡିସବିଲିଭ ହବ ଯେ ଅତୀତରେ ମଧ୍ୟ ଆପଣ ଆପଣଙ୍କ ସ୍ତ୍ରୀକୁ ଆସଲ୍ଟ କରୁଥିଲେ, ଯୋଉଥିପାଇଁ ସେ ଯାଇ ତା ବାପ ଘରେ ରହିଥିଲା, ଏବଂ ଇଏ ପୁଅଟି PW2 he just brought the deceased back within 15 days, that ହେଲା, prior to 15 days of the affair, and then this incident happened.
Another disbelief, my lord, the ପୁଅ କହୁଛି myself, my wife and my parents were living under one roof and one mess.
କଣ ଅସୁବିଧା କଣ?
My lord, another witness also କହୁଛନ୍ତି PW4, my lord, in his cross examination se କହୁଛି PW para 2 cross examination. I have not seen the assault in the Kalpana. At the time of my arrival, she was already dead. The dispute between the accused and his wife was never reported to the police station. After their marriage, PW2, my lord, and his wife were living in separate mess from their parents.
ମାନେ କଣ ହେଲା?
ଏମାନେ ଆକ୍ଚୁଆଲି ଏମାନେ ସେ ଯୋଉ କହୁଛି PW2 ଇନଫର୍ମାଣ୍ଟ କହୁଛି ଯେ ଆମେ ଗୋଟେ ଛାତ ତଳେ ରହୁଥିଲୁ, କିନ୍ତୁ PW4 କହୁଛି ଯେ ଏମାନେ ସେମାନେ ତାଙ୍କ ବାହାଘର ପରଠାରୁ ଅଲଗା ହେଇକି ରହୁଛନ୍ତି,
ଅନ୍ୟ ଫ୍ୟାମିଲି ମେମ୍ବରଠୁ ଅଲଗା ହେଇ ରହୁଥିଲେ, ସ୍ୱାମୀ ସ୍ତ୍ରୀ
ସେ ତାଙ୍କ ମେସ୍ ଭିତରେ ରହୁନଥିଲେ, ତାଙ୍କ ପ୍ୟାରେଣ୍ଟସ ଭିତରେ ରହୁନଥିଲେ।
ହଁ, ସେଠୁ କଣ ହେଇଯିବ? ହାଉ ଦି in what way that affects the evidence of PW2, who is your son? Why he would falsely allege against you? One side his mother is there, the other side you, the father, is there. So
PW3 corroborated PW2.
PW2 3. PW3 is also another
wife of the PW2.
Oh, he has also stated that.
My lord, PW3 already ବି କହିଛି ଯେ he para 2 ରେ, my lord, he also dealt another blow to other side of her neck and a blow on her face, but doctor examination ଗୋଟେ କରିଛି।
That's all. Are the learning counsel for the petitioner, learning counsel for the state. The learning counsel for the petitioner submitted that the petitioner is in judicial custody since 1/1/2017, and as per the prosecution case, the petitioner stated to have assaulted the deceased with a tangia, and though it is stated that he gave 3 to 4 blows on the neck, but the doctor bracketed PW7 who conducted post-mortem examination has noticed only one incised wound on the left neck, which falsifies the evidence of the eyewitnesses. The learning counsel further submits that the eyewitnesses have stated that previously the petitioner used to assault the deceased, but in that connection, no first information report has been lodged in the police station. And in view of the available material on record, there are good chances of success in the appeal, and balance of convenience is in his favor. The এটা कितना number item 31 na? And even though paper book has been prepared, there is no chance of early hearing. Therefore, the bail application may be favorably considered. Learned counsel for the state, on the other hand, oppose the prayer for bail, place the evidence of PW2, the son of the deceased and the petitioner, so also PW3, who is the daughter-in-law of the petitioner and the deceased, but the good take like the son and daughter-in-law. And both of them have stated as to how the petitioner assaulted the deceased on the neck with tangia. Whether the evidence of the two eyewitnesses is to be believed or not in view of the post-mortem report finding is to be decided at the stage of final hearing. However, the manner in which the crime has been committed, the vital part of the body on which the tangia blow has been given, and coupled with that instantaneous death of the deceased, we are not inclined to, and since the paperwork has already been prepared, the matter will be added to the hearing list in the third week of August 2024.
Bill rejected.
Yes.
Given me one chance.
Yeah.
I would chance there.
Get ready for arguing the matter. Paper book, you receive the paper book and get ready. Yes, next.
Yes.
Item number 32.
On behalf of Mr. S.K.Dash, kindly pass over for the day now.
Okay, it is there, it may be taken. Tomorrow it will be called.
All right.
Item number 33.
My please, Lordship. Your Lordship may take sub item first, my lord.
33.
Sub item first, your Lordship may.
JCRA 25.
My lord. I filed an IF for bail, my lord.
For appellant number 2.
For appellant number 2, my lord. My lord.
What is the name of the appellant number 2?
Pardon, my lord.
What is the name of appellant number 2?
Pandru Munda, my lord.
Pandru Munda, yes. In original Sessions case, he was petition number, he was accused number 1.
এটা করা গেল যেটা রিসিভ করে এটা তো জেসিআরএল না না সিআর জেসিআরএল প্রিজনার্স পিটিশন কাই সেটা প্রিজনার্ସ ପିଟିସନ ଅନୁଯାୟୀ ସୋନୁ ମୁଣ୍ଡା କଣ
ସୋନୁ ମୁଣ୍ଡା ପାଣ୍ଡୁ ମୁଣ୍ଡା
ସୋନୁ ମୁଣ୍ଡା ହଉଛି ଆପେଲାଣ୍ଟ ନମ୍ବର 1 ବା ସିଏ ଏବଂ ସାଇନ୍ କରିଛି ପାଣ୍ଡୁ ମୁଣ୍ଡା ସୋ ଦିସ୍ ଇଜ ଫର ପାଣ୍ଡୁ ମୁଣ୍ଡା
my lord.
And you have been found guilty under section
302 201 34 IPC read with section 4 of the PWH Act, my lord. Prevention
witch hunting,
my lord. My lord, custody since 25 to 2016, my lord.
25 to
my lord
2016,
16, my lord.
So
I filed the bail on the ground of health ground, my lord. Earlier, this honorable court granted 3 months bail, interim bail, on 3/12/2022, 20, my lord.
In this application, what stand you have taken?
My lord, he is seriously ill, my lord. Both
Who is ill? Who is ill?
appellant number 2, my lord, Pandru Munda.
So, what is your instruction, Mr. Das? The government that has been taken in paragraph 5 and the medical documents annexed, and he said that earlier he was granted interim bail on this health ground, and what was his behavior at that point of time, conduct, and whether so you are granted bail for what period? 3 months.
3 months.
That is the order dated 3/12/2020.
2020.
So through the concerned jail superintendent you obtain instruction.
instruction ଥିଲା 2020 ମସିହାର
ନାଇଁ
ଏବେ recent
Mr. Counsel,
My lord.
this is a
I of 2020.
2020.
My lord.
So you file a
Pending, my
fresh
lord. That is pending, my lord.
pending, but file a fresh application. That how do you say that this is the condition? 2020 upon file କରୁଛନ୍ତି, we are in 2024, and
all these prescriptions are of 19 and 2020.
Recent documents you annexed and file a fresh application. Look, IA number 64 of 2020. This is an application for interim bail of appellant number 2, Pandru Munda. The London Council for the petitioner seeks permission to withdraw this interim application to file a better one. Accordingly, IA is disposed of as withdrawn. Hello? Yes. Yes.
Item number 34.
Hey, please, Your Lordship. Your Lordship, I'm representing Mr. C.Sahoo. Last time, the instruction regarding CA report has been called for.
Yes, Mr. Das.
No CML.
You are in custody since 6/1/2016.
Yes, Your Lordship.
Your earlier bail application was rejected, or it is the first one?
This is the first one, Your
First
Lordship.
one. And you have been found guilty under section
302 of IPC.
Okay. Who is the deceased? What is the name of the deceased?
The deceased is Srushtidhar Malik.
Srushtidhar.
Dhar Malik. He's the father of the informant.
When the occurrence took place, date of occurrence?
The date 5/1/2016.
Eyewitnesses are there?
Yes, Your Lordship.
Who are the eyewitnesses?
PW7.
And with the doctor who conducted PM?
PW8.
PW10.
Sorry, Your Lordship, PW10.
PW10. So you come to PW7's evidence. Has he supplied the? Okay. PW7 is Arnapurna Malik.
Yes, Your Lordship.
Please face paragraph number 2.
The occurrence took place about 1.5 years back at about 5 a.m. on the road in front of our house. At that time, I was inside my house, hearing some sound. I came outside of my house and saw accused Sarath assaulting the deceased by a stick. I rushed to my house and called my family members. Then I came to the spot and found the wife and daughter of deceased were crying, and the deceased was lying on the ground and sustained bleeding injury on his head. The road was also soaked with blood. The wife and daughter of the deceased took the deceased to the hospital. I was examined by police.
Okay, so you gave stick blows to the deceased. And what is the report of the doctor PW10? Let us see.
Lordship, there was 5 injuries. Total 5 injuries.
One on the right leg, the last one, number 5, but other injuries are on the face and head. The cause of death has been opined to be complication on account of craniocerebral injuries.
Yes, Your Lordship.
So why you assaulted the deceased? Any kind of
Yes, Your
statement has
Lordship.
been made by anyone?
Your Lordship, it's on judgment para 2. The case of the prosecution, in brief, is that there was ill feeling and civil litigation between the families of the informant with the accused person. Prior to the occurrence, the accused person threatened to kill the father of the informant, Srishtidhar Malik, on
This
dated.
wife and daughter of the deceased,
Yes, Your
who
Lordship.
they are at this, they have not been examined.
Yes, Your Lordship. Daughter
Who
is
are they?
PW1, informant.
PW1
Yes, Your Lordship.
is the daughter.
Yes, Your Lordship. Informant.
So please
And
come to
PW5 is wife of the deceased.
same thing he has stated. You assaulted on the head of the deceased with a bamboo stick. And PW5, of course.
It was 6 also correct.
Hmm?
It was 6 also correct.
But Your Lordship, in PW7, cross-examination, it was stated that I heard the sound of the falling of cycle, and hearing the sound, I came outside of my house and found the deceased lying on the road. At that time, no other family members of the deceased as well as of accused Sarath were present at the spot. Your Lordship, those are PW1 to PW6 are the post-occurrence witnesses. Only the PW7 are the eyewitness to the occurrence. Grandfather of the informant.
Schedule 4 also,
Schedule 4 is saying that he saw him assaulting.
assaulting. Sarath assaulting the deceased on his head by a bamboo stick.
And accused Bapina assaulted the deceased by
Iron rod
on his
leg.
So there is injury in the leg
My lord.
and hand.
And the accused Jati Malik specifically has
The present person. Jati Malik assaulted
the deceased by a stick. This PW7
which you first placed as an eyewitness to the occurrence. And he has stated you to be assaulting the deceased by means of a stick. So you have not even suggested that it is on account of fall from a cycle that these injuries were caused. Nothing that this witness person
The opinion in Dr. Para 3, my lord, regarding the bamboo stick used and the cause of injuries due to the bamboo stick, that has been clarified.
doctor has also not been put that this possible by this fall from the cycle. ଗୋଡ଼ fracture বিভিন্ন ଜାଗାରେ injury ହେଇଛି.
So basing on which ground you seek your matter to go in your favor and appeal? Apparently.
Your Lordship, in PW 10 deposition, Doctor, in para 6, was stated it is not a fact that the bruise can be possible after the death of a person. It is a fact that I have not mentioned the word exhibit in Exhibit 5. On the same day of my examination of the bamboo stick, I handed over the same to the police. There was no visible blood stain on the bamboo stick. It is not a fact that I have prepared Exhibit 5 of the instant of police.
Technically, substantively, with regard to the injuries, nature of injuries. Direct assault by you.
You have remained in custody for 8.5
years.
8.5 years.
Years, 5 months.
6/1/2016 you said.
Yes, Your Lordship.
Any report is there? Mr. Das, any report? No. No report is there. Adverse report is there.
No negative. No antecedent.
No CA is there.
No CA.
No antecedent.
No.
Are the learned counsel for the petitioner, learned counsel for the state. The learned counsel for the petitioner submits that the petitioner is in judicial custody since 6/1/2016. The occurrence in question took place on 5/1/2016, and as per the eyewitness account of PW7, the petitioner assaulted the deceased by means of a stick. However, the PW5, who was that witness, has stated that he fell down from the cycle. PW6 na go press করতে
PW7.
ଗୋଟେ ସାକ୍ଷୀ ପ୍ଲେସ୍ କଲେନି? ହଁ ସେ ଗୋଟେ କାହାର
Your Lordship, PW7.
PW
7.
7.
Oh, no. Having fallen a cycle seeker. Sound of falling.
Saw the accused assaulting the street. Nobody has stated that. You said that the evidence of this witness contradicts that he was assaulted by any weapon. Rather, he fell down from the cycle and received the injuries.
Yes, Your Lordship.
Who is that witness? ସେମିତି ତ କେହି ୱିଟନେସ୍ କହିନାହାନ୍ତି। Everybody has stated that you assaulted by means of a stick, bamboo stick, and no one has stated that on account of fall from a cycle he received injuries. Anyone stated like that?
That was on impute judgment, para 2.
Which portion? Kindly read.
Lordship,
Kindly read which portion.
at the juncture, accused Sarath Malik with an intention to murder Srishtidhar dealt a bamboo lathi blow to the backside of the head, as a result which he sustained bleeding injury and fell down on the road. Thereafter, other accused person assaulted Srishtidhar by means of bamboo lathi and iron rod. Hearing the shout of Srishtidhar, the villager rushed to the spot for which accused person left the place.
No, you made a statement that he fell down from the cycle. One witness has stated and received the injuries. Is there any such statement? ଯେତେବେଳେ submission ଟା କରୁଛନ୍ତି କୋଉ statement ଯୋଉ କହୁଛନ୍ତି ନା ସେ କୋଉ statement କିଏ କହିଛି ସେମିତି ଯେ ସାଇକେଲ ରୁ ପଡିକିନା ଇଞ୍ଜୁରି ହେଲା ବୋଲି? ସେଇଥିପାଇଁ ଆମେ ତ କହିଲୁ ଯେ ଆପଣ ସଜେଷ୍ଟ କରିନାହାନ୍ତି ଯେ
Here, Lordship, in Exhibit 7, deposition, cross-examination by the defense.
Exhibit 7.
Exhibit 7 or statement of PW7?
PW7, Your Lordship.
Okay, let us see that.
Deposition, cross-examination. I heard the sound of falling of a cycle, and hearing the sound, I came outside of my house and found the deceased lying on the road. At that time, no other family members of the deceased as well as accused Sarath were present at the spot.
Oh, that statement you are relying.
Yes, Your Lordship.
All right. कौन लिख ले? Eyewitness. But evidence of but the evidence of PW7 in the cross-examination indicates that when he came to the spot, hearing the sound of falling of a cycle, he found the deceased was lying on the road, and at that time, no family members of the deceased, as well as accused, as well as the petitioner, was found present at the spot. Learned counsel submits that in view of such statement of PW7, it appears that the family members of the deceased were post-occurrence witnesses, and the deceased received injuries on account of falling from the cycle. It further submits that there are good chances of success in the case and paperwork has not been prepared. Therefore, the bail application may be favorably considered. Learned counsel for the state, on the other hand, submitted that PW1, apart from PW7, PW1 and PW5, they have PW4. PW7, PW1 and PW4 have stated about the assault being made by the petitioner to the deceased with the stick. And PW10, the doctor who conducted postmortem examination has noticed injuries, 5 injuries, out of which 4 are on the head, and the 5th injury was a fracture on the right leg, lower right leg, and the doctor has opined that death was due to complication on account of craniocerebral injuries. Considering the submission made by the learned counsel for the respective parties, the eyewitnesses account, the manner in which the offenses been committed, and the evidence of the doctor, while not inclining to release the petitioner on bail, but taking into account the period of detention of the petitioner in judicial custody and absence of any chance of early hearing of the appeal in the near future, and taking into account the ratio laid down in the Letty versus State, we are inclined to release the petitioner on interim bail for a period of 3 months. The report we called for, date is to be fixed after 3 months to file the surrender certificate. Yes, give your name in a slip.
Obliged, your lordship.
Item number 35.
Present appellant is in custody since 28/10.
CA ପାଇଁ
11
ଥିଲା,
minor.
କାଲି ତ tomorrow it will be taken. Yes.
Item number 36.
Mr. Chittaranjan Sahu, S.K. Jafrullah. Next.
Item number 37.
Please, my lord. My lord, here I am appealing for the appellant number 1, my lord. My lord, here the appellant is also in custody since 21/3/2016. My lord, that 21/3 21/3/2016.
Appellant number 1, his name is Damborudhar Bhatra.
Damborudhar Bhatra, my lord.
Okay.
My lord. So far the allegation is concerned, my lord, that the deceased, namely Mansingh Bindhania, who is also, my lord, that is having a criminal record, that he was also languishing in jail custody in state of Orissa as well as in state of Chhattisgarh in different cases. Mainly he is indulging in theft. So far the allegation is concerned that the valuable trees which has been planted by the petitioner and others, that has been stolen away by the deceased, and that was the allegation. My lord, thereafter that only that is the wife of the deceased, she is the eyewitness, state that making an omnibus allegation that there is no specific allegation that the accused assaulted the deceased, because they are making an allegation of many accused persons.
Is it a case of direct evidence or circumstantial evidence?
Direct evidence.
Who is that eyewitness?
PW 22.
PW 22.
That the wife of the deceased.
Wife of the deceased.
Dalimba Bindhania.
And who is the doctor who conducted?
Doctor is PW 21. PW 21 is the director.
You come to first PW 22.
22, sir.
Let us see what he has stated against you. Damborudhar.
Yes. The informant is my brother-in-law. Being the elder brother of my husband, I know all the accused persons standing inside the dock. The occurrence took place about 2 years back at 6 p.m. on Kenduguda Saraguda road over the bridge about 3 kilometers from our village, Kenduguda. On the relevant day at 6 p.m. while I along with my husband, Mansingh Bindhania, now deceased, and my elder sister, Konduri Bindhania, were returning to our village Kenduguda from Saraguda. On the way near the bridge, suddenly the accused persons, namely Damborudhar Bhatra, Raju Bhatra, and Manoj Bhatra, appeared, who hidden under the bridge. Accused Damboru Bhatra was armed with an axe, Tangia, and other accused persons, Raju and Manoj, were armed with lathis. About 6 to 7 other culprits also arrived there. The accused persons threatened my husband Mansingh by saying as to why he has cut tree and they were protecting the forest. Saying so, accused Damboru assaulted on his neck, right hand and left leg by means of an axe. Other 2 accused persons, Raju and Manoj, assaulted all over his body by means of a lathis. My husband requested the accused persons not to assault him with the folded hands, but the said accused persons did not
listen and assault going on assault. As a result, he fell down with injuries on his person. I, along with my sister Kenduri, when protested, accused Raju Bhatra dealt a lathi blow on her left leg. I told her to flee away to save her life. Accused Domburu Bhatra assaulted on my right hand and
So she is a injured eyewitness,
yes.
right?
Yes.
And stated that you are that person who assaulted the deceased by means of a sharp cutting weapon like axe and
Yes.
dealt blows on the neck,
My lord,
right hand and left leg.
my lord.
So what is the evidence of the doctor? PW 21.
Sir. On 21/3/2006, I was working as a medical officer, CSC.
So Talimba means that PW 22. He has sustained number of injuries
Sir,
as stated.
Sir.
Now you come to the post-mortem report, paragraph 2.
Sir, on 21/3/2026 on police requisition 2016 police requisition, I conducted the autopsy on the dead body of the Mansik Vindania, son of so-and-so, the village so-and-so. The lacerated wound over the right ear of size 2 cm in length. Fracture of left forearm radius and ulna near the wrist joint. Lacerated wound 2 in numbers, each in size 3 cm length and 5 cm depth, presented over the back of the head. Lacerated wound superficially in the nature and the linear of the size 1 cm in length, present over the back of the head. Multiple lacerated wound of the size 1 cm length is present over the lateral surface of the forearm, just at the middle of the forearm. Fracture of both labia and fibula of both lower limbs at the middle of the leg. Lacerated wounds over the skin of the tibia and both lower limbs of size 1 cm into 1 cm. The multiple grievous injury found over the body of the causing damage a vital organ like the brain, resulting the hemorrhage of the shock. Cause of death was due to massive cerebral hemorrhage. Nature of death is homicidal. Time since death might be within 18 to 22 hours.
The version of the eyewitness that you have assaulted by means of a tangia.
Sir.
And the injury sustained by the deceased as per the. So what you want to say?
That was the omnibus allegation.
What omnibus? Omnibus कौन सी पर कहला कोउथरे मारला
सर ओनली आई मे ड्रॉप
को जागा को मारला एवं सेई करेस्पोंडिंग सेई जे जागा रे मध्य पीएम रिपोर्ट रे इंजुरी आसुची ओमनिबस कोन कहत.
He has said that though the appellant number 1 holding the tangi and assaulted, similarly also the other accused persons also assaulted the deceased.
Because there are
multiple injuries. Multiple injuries.
So, but you see what is the cause of death? The cause of death, as per PW 21's evidence, is the injury which is caused to the head that resulted in the death of the deceased. The cause of death was due to damage to the vital organ of the brain, resulting in hemorrhage and shock.
Sir, there was no specific allegation against the appellant number 1 that he has also assaulted by the means of axe on the head, because the combined attack by all the accused persons. Please see the only the cross examination of that PW 22, sir. Prior to the incident, PW 22 180. Prior to the incident, a police case was instituted against my husband Mansingh on the allegation of assaulting the in charge of the Dabuga PS about 3 to 4 months in a criminal theft case were also instituted against my husband at Dabuga PS, Umarkot PS in the state of Chhattisgarh. He was also inside the jail custody for about 5 years at Koraput jail. We were not pulling on well with the villagers prior to this incident. The villagers of the Kenduguda ostracized our family.
All right, that he is an antisocial. let us say, to go to that extent
Sir.
that he has a number of criminal antecedents, and he was also in jail custody for some years. But that does not give you any right to assault the deceased and finish him in this manner.
No,
Who has authorized you to assault?
10 to 12 assailants were there. We said that 10 to 12 assailants also assaulted the deceased.
But
Not only
you are the main person.
I was holding the axe.
Your overtake is very clear.
Not only axe only, because the other assailants also assaulted the deceased. Because there one is holding iron rod, another is holding another weapon. They have also assaulted.
And what about your criminal antecedent?
There is no criminal antecedent against me. Because I am a simple villager. I am also protecting the forest, and the valuable forest trees are also taken away. Because he is having a very tremendous criminal record.
So merely because he caught the forest land or trees, you will caught in.
No, because out of our labor, we have also developed a tree. It is very difficult.
Report the matter to the police center. Why did you take law into your own hand? Yes, Mr. Das, any criminal antecedent?
Another eyewitness, my lord.
PW9.
Not specifically, but regarding the weapon they are carrying, that he has categorically.
Mayadar Vinhania. 2016, my lord, is in languishing in custody. I got the custody certificate.
At the time the occurrence, the accused Samaru was armed with a knife and accused Madan was holding an axe.
Accused?
He was holding an axe.
Yes, ma'am.
This, what this witness has stated, PW9, you said?
Mayadar Vinhania. Maya.
I saw the accused person comically attacking the deceased, being armed with cudgels and knives and axes and iron rods. Due to such brutal attack, the deceased sustained severe cut injuries on his neck, shoulder, legs, and other parts of the body, and died there instantly. At the time of the occurrence, accused Samaru was armed with a knife, and the accused Madan was holding an axe.
Madan was also holding an axe.
Accused Manohar was holding a cudgel, and accused Dhaniram was having
an iron rod.
Out
of fear and shock, I fled away and took the spot. And in cross again we stated.
What about the others?
He is appearing for 227.
Is there any criminal antecedent, Mr.?
I have to obtain, my lord.
All right.
The custody certificate.
I have given custody certificate.
Custody certificate you produce in the Learning Council.
You want more?
এটা কোন 7 ବର୍ଷ ଲେଖା ହେଇଛି
8 ବର୍ଷ ହେଇଗଲା already 8 years 8 ବର୍ଷ ହେଇଗଲାଣି
13/7
ଆଜି ହିସାବ କଲା 8 ବର୍ଷ
13/7 ଏବେ ତ 13/7 8 ବର୍ଷ କୋଉଠି ହେଲା The Learning Council for
13/7 2024
has produced
11 ମାସ ହେଲା 7 ବର୍ଷ 8 11 ମାସ
କୋଉଟା
ଦେଖୁନ 7 ବର୍ଷ 11 ମାସ 22 ଦିନ 7 years 11 months 22 days କେତେ ହେଲା
7 ବର୍ଷ 11 ମାସ 22 ଦିନ ହଉଛି ସେ 22 ରୁ ଆଉ 8 ଦିନ ମିଶିଗଲେ ସେ ସେଇଆ କହୁଛନ୍ତି ତ 7 ବର୍ଷ 12 ମାସ ହେଇଗଲେ ସେ କହୁଛନ୍ତି ସେଇଆ The Learning Council for the petitioner has produced the custody certificate which is taken on record. The Learning Council for the state seeks some time to obtain the criminal antecedent, instruction about the criminal antecedent if any against the petitioner. Petitioner means appellant number 2.
1.
Both the କେତେ ଜଣ appellant ଅଛନ୍ତି?
Total 7.
So bail application has been filed for appellant number 1 and 2.
I am for one.
Only for one.
I am for only
No, somebody
one.
has filed for
filed
two.
for bail, my lord. I am number
2 to 7, acha. All right.
All the appellant-
For all the appellants.
Right.
Hello? Okay. Matter to be listed in the week commencing from 5th August. Hello? Yeah.
Item number 38.
If there is a lordship, here the appellant seeks a release, file a miscase for release or on bail, as he is inside custody since more than 10 years for alleged offence under section 302. And all other.
Can you tell us the date of custody, or have you got the custody certificate?
Date of custody, my lord. 15/1/2000.
Yes.
My lord, my lord. 15/1/2014.
Your appellant is? Who is your appellant?
But I am the sole appellant. The other has been released on bail for alleged offence.
What is his name?
Bharati Kanta alias Santi Kanta.
Bharati Kanta.
Alias Sona alias Santi Kanta.
17/1/14.
That means it is for appellant number 1 you have filed the bail application.
The other accused person has been released on bail. Oh,
So, eyewitness is there?
no eyewitness.
No eyewitness. Then what is the circumstantial evidence against?
My lord, the occurrence took place in a closed room.
Deceased is one Prahlad Kanta.
Happens to be the husband of the accused person.
Acha. So, you are staying with her husband
My lord,
in that room where the dead body was found.
where the dead body was found. And death is due to strangulation.
Who else was residing in that house? Is there any other evidence?
They were not living. They came to this. They were present in the spot as alleged that during the time of occurrence. They were not staying in that. I was staying in a single room, and they were the neighbors.
Well, can I come to the evidence of the Procedural 6 and 8? 6. Step please करो.
9 of 9 of 6.
That's what.
This paragraph 3 indicates, Mr. Das, that there are other persons who are also present there.
Yes, ma'am.
When I opened the door, found all the accused persons. I also noticed 3 motorcycles. On being asked, accused Padma, this lady is not Padma, I think. Bharti. So one Padma told me that she had come to the quarter of deceased along with others as because they were asked by accused Bharati to come there. Accused Padma then handed over the key of the grill lock of the quarter of the deceased Prahlad and told that they were going to the house of PW3. Accused Padma also told that deceased Prahlad had slept and was not waking on being asked to him. Accused Padma also told the key of the grill to be handed over to the mother of the deceased by me. Thereafter, they all went away in 3 motorcycles. On the following day, so I went to the quarter, and as he did not, I went to the house of so. Then came, grill was opened, they entered, and then around the so black ligature mark was found. So what he says that if this is the case, all the accused persons came and the crime was committed by either one of them or later. But when the others have been released on bail, what he says, and how you are saying that it is only the wife is to be, who are being granted bail according to you? And in which CRLA?
My lord, CT case number 60 of 2014. Learned additional session just.
Can you come to the evidence of the P2, my lord?
All the accused persons who were facing trial, they found guilty under section 302 by 34, or any of them have been acquitted.
302, 34 IPC.
No, all of them have been.
All of them, my lord.
So, sessions that granted bail means?
Mr. Counsel, you are making a wrong statement. Please come to paragraph number 31. This should not be the statement expected from you. Please come to paragraph number 31 of the impugned judgment. All other accused persons, they have been acquitted, and it is only you who has been found guilty under section 302. Now you are giving an impression on us that as if all of them have been found guilty and the rest have been released on bail, and you are the only person left out. Please see paragraph number 31.
31.
Yes.
My lord.
Why are you making such type of statement in court?
My lordship, I was reading page 9, where I was going on.
Mr. Counsel, you are arguing a bail application in the High Court and a 302 matter where life imprisonment. Is it not expected from you to read the entire judgment? Is it not expected that on what basis the judgment of conviction, why the others have been acquitted, why you have been found guilty, and how to meet that evidence? And you are making a wrong statement in court. Get yourself prepared. We are taking up this matter. This is not the way to make a submission. The learned counsel for the petitioner seeks for an adjournment. Please this matter. We commencing from 29th July 2022. Yes, next. Why you have filed two interim applications for bail? If it is for the only one appellant is there, Bharati Radhikila, Ketrion appellant is one appellant, why 2 bail applications?
My bail application, lordship, is 1645 of. Initially, it was for 1645 2022, lordship.
Then why another bail application has been filed? 2443 of 23. During pendency of one bail application, why another bail application was filed by the petitioner? If it would have been an interim bail application, matter is different.
No interim.
But again, another bail application has been filed. So one, yes, you are to withdraw it.
No.
Which one you want to withdraw?
I want to put 2443 and 2451 for sterilization. That two should be there.
2443 want to withdraw.
No, that I will withdraw the previous one.
Okay, 1645. All right. 1645 of 2022. This is Land Council for the appellant seeks permission to withdraw this interim application disposed of as withdrawn. IA number 2443 of 23, 29/7, 2024, and IA number 2451 of 23, stay realization of fine to allow for them. Yes, next.
I'm the applicant, I'm the lady applicant, and I'm in custody since 15 for 2017.
Just a minute. It is item 39 CRLA 871 of 2022. Tulosa Hon'Ble. Are you the sole appellant or anybody else is there? No sole appellant. So you have been found guilty under section 302. Okay. What is the prosecution case? Took place on so and so. Victim come injured was asleep on the veranda of their house with the sister-in-law of the deceased. Affected them by means of acts causing death of the deceased. Victim come injured or shifted to so and so. Informant. The evidence of the doctor has been discussed in paragraph 9 of the judgment. PW15 is the medical officer who conducted postmortem examination, and the report indicates that multiple chop wounds on the left side neck and lacerated wound on the occipital region. And he has opined the cause of death was due to injury to the vital organs, that is brain, and important structures passing through the neck. Now, he has come to a finding that the death was homicidal in nature. Then he has relied upon the evidence of PW3. Let us see the evidence of PW3 eyewitness.
Eyewitness PW7, injured eyewitness.
PW7. PW3 is not an eyewitness.
Then PW7 is the injured eyewitness.
Acha, let us see that. PW7 को ऐसे करना. Occurrence took place 3 years back. After observation, I and my husband came to our village and took dinner and slept in this one. The accused Tulsa Hon'Ble and her husband came to our house. Accused Tulsa dealt tangia blows below my lips, front side neck, back side neck, overhead, all on a sudden. Then the accused dealt tangia blow to my husband, sustaining injuries all over his body. I became senseless. So your date of custody is
15/4/2017. That is in page number 4 of the judgment results. Page running to 21.
7 years completed. So the even if you are a lady, you have assaulted. Why there was previous dispute was there or not? Why the assault was made by this lady on that accused? What is your submission, learned counsel? What do you say? You have dealt the blows by means of an axe, no? Tangia, and you see the injuries which are noticed by PW15, and PW7 is the eyewitness to the occurrence, the wife of the deceased. So she is also an injured eyewitness. So her presence at the scene of occurrence cannot be disputed and the manner in which you have assaulted multiple chop wounds on the left side of the neck and lacerated wound on the occipital region. Are the learned counsel for the petitioner, learned counsel for the state. The learned counsel for the petitioner submitted that the petitioner is a lady and she is in judicial custody since 15/4/2017. And the case of the prosecution is that petitioner assaulted the deceased by means of an axe, and in view of the available material on record, there are good chances of success in the case, and balance of convenience is in favor of the petitioner, and therefore the bail application may be favorably considered. Learned counsel for the state, on the other hand, oppose the prayer for bail and praise the evidence of PW 7. PW 7. Dasu Hon'Ble, who is the widow of the deceased Dhanna Hon'Ble, and she has stated how the petitioner assaulted to her first and then to the deceased husband by Tangia on different parts of the body. The learned counsel for the state drew the attention of the court to the evidence of the doctor PW 15, who conducted post-mortem examination and noticed the deceased to have sustained multiple chop wounds on the left side neck, so also lacerated wound on the occipital region, and the cause of death has been opined due to injury to the vital organs like brain and the important structure passing through the brain. Considering the submission made by the learned counsel for the respective parties in view of the available material on record and the post-mortem report finding, while not inclining to release the petitioner on bail on merit, but since she is a lady and has remained in judicial custody for more than 7 years, we are inclined to, and there is no chance of early hearing of the appeal in the near future, we are inclined to release him on her on interim bail for a period of 3 months. Baki usual order kar debe. The report has to be called for regarding her conduct while on interim bail, and the matter is to be posted after 3 months, so that she will file the he'll file the surrender certificate. Yes.
Item 30.
My pleasure, Lordship. At
40 na 41?
40.
Acha, 40.
And both the appellants are convicted under section 302-34 of IPC and 506 manner. Custody since 25/8/2014.
Just 40, it is CRLA 941 of 2022. Emolota Luhari. What is the date of custody?
25/8/2014.
25/8/2014. And you have been found guilty under section
302-34 of IPC. And another appellant is convicted 506.
Acha. What is the name of the deceased?
Deceased man Siba Luhari.
Siba Luhari.
Luhari.
Date of occurrence is 24.
Date for 24/8, my lord, 2014.
Eyewitnesses are
My
there.
lord, only for two PW 9 and 10, both the appellants are convicted.
PW 9 and
9 and
PW 10 are the eyewitnesses.
child witness.
And who is the doctor who conducted?
PW 15. 9 and 10 child witness. All other are hostile and not.
So what she has stated that child of
PW 9, my lord.
PW 9.
The informant is my father's elder brother. This Bodappa. The accused Kasinath Dehuri is my own kaka, and the other accused Hemolata is my mother. The occurrence took place on a Saturday at night. I was sleeping at home along with my father, mother, and brother Krishna Chandra. Hearing a sound, myself and my brother got up at about 12 midnight. When I got up, I saw that my father's snake had been tied by a rope by my kaka and my mother. My mother told us that my father had been killed by Bondara, that is Chwadara. On the next morning, the accused, who is my kaka, told me that my father is dead. I was examined by the police in connection with this case, and my statement was also recorded by Lauren Etijem. Withdrawal, I am also called Ganga. I was studying in class 3 at that time. Exhibit 8 is the statement recorded under section 132 CRPC, and exhibit 8/1, 8/2 are my signature thereon. My father had been killed by my kaka and my mother. And in cross, my lord stated that it was a dark night. There was no light in the room where we are sleeping. It is a fact that my father used to go outside the village to Paradip, Bhubaneswar, etc. for work. It is not a fact that accused person and my grandfather used to look after the affairs of my family. Gurubari Luhari is my father's second wife, and she used to feed us in the absence of my father. It is a fact that I had not stated before the police that my father's neck was tied with a rope by the accused person. It is not a fact that I had not stated before the police that my father told us that my father had been killed by the Pandora, that is Chwadara. It is fact that my father had been to the hut on that day occurrence and had brought mutton but not fish. My father used to consume liquor. It is a fact that my father had consumed liquor and mutton before going to sleep. The witness volunteers that her father was made to consume liquor by the accused kaka. It is not a fact that my father died due to food poisoning after consuming liquor and mutton. It is fact that there was a landed property dispute between my father and kaka prior to his death. It is a fact that my father was not pulling on well with his first wife Hemolata. My stepmother Gurubari was not present when my father had consumed liquor at the time of occurrence. It is not a fact that the accused person had not killed my father, and I am deposing falsehood. We had not slept the whole night and we are present in the said house. It is not a fact that I had not slept in the said house that night. The witness volunteer here that after her father died, they left for Kajal Buddha's house to sleep. It is not a fact that deliberately I am deposing falsehood.
How this is the another evidence is of PW 10 also, another child witness.
Same statements are there.
So same thing is there.
Same statements are there, but they're not seen the as there is a dark night and also there is no light is present.
No,
and
your
also
presence was there, and that rope and tied around the neck, and the doctor has opined that the injury detected can be possible by the rope produced. PW 15 is the doctor, and there are injuries on the neck and upper part of the anterior part of the chest. Multiple bruises are there, and cause of death was been opined to be asphyxia. So ଆପଣ ଯୋଉ ସଜେସନ ଦେଲେ କଣ ମଦ ପିଇ ଦେଇଥିଲେ ଆଉ କଣ ଖାଇ ଦେଇଥିଲା, so that is not the cause of death.
other witnesses are also hostile. And,
25/8/2014 মানে
9 year 11
9 years
11
are the land and counsel for the petitioner and counsel for the state. The land and counsel for the petitioner submitted that the petitioner is in judicial custody since 25/8/2014. and the allegation, the prosecution case against the is that petitioner killed her husband, Sibo Luhari, and the occurrence in question took place in the night, in the intervening night of 25-26 or
24, man.
24 or 23-24, intervening night 8 2014. And from the evidence of two eyewitnesses, that is PW9 and PW10, were the child witnesses, it would appear that the spot room was dark, and therefore it is, and the witnesses were also sleeping at the time of occurrence, and therefore it would not have been possible for PW9 and PW10 to see the occurrence, and there are good chances of success in the case, and balance of convenience is in favor of the petitioner, and therefore the bail application may be favorably considered. Learned counsel for the state, on the other hand, placed the evidence of PW9, who is the
Childhood.
Now with the son,
Son,
daughter,
son.
with the son of
PW9
the,
is the
with the son of the
no, my lord. PW9 is the daughter.
daughter.
PW10 is the son.
All right, PW9 is the daughter of the appellant. Um, with the daughter of the deceased and the appellant petitioner, and the PW10 is the son, and their evidence is getting corroboration from the evidence of the doctor, bracketed PW15, who has stated that the cause of death was asphyxia, and he also examined the rope which was sent to him by the IO, and it was his opinion that the not only the deceased met death which is caused on account of asphyxia, but the injury, that the injury detected could be possible by the rope produced. Considering the submission made by the learned counsel for the respective parties, the evidence of the two eyewitnesses PW9 and 10, so also the doctor PW15, while not inclining to release the petitioner on bail on merit, but since the petitioner is a lady and she has remained in judicial custody for more than 9 years, we are inclined to release or on bail. In contact with ସେଇଟା ବି ବଡ ହେଇଯିବନି ଆଉ 2021 କେବେ ହେଇଥିଲା ଏଗୁଡା PW9 ର ବୟସ ହେଇଥିଲା 2019-13 ମାନେ ବର୍ତ୍ତମାନ 5 ବର୍ଷ ମାନେ 18 ହେଇଯିବ ଆଉ ୟାକୁ ହେଇଥିଲା 2019-ରେ 12 ସେ ବି ହେଇଯିବଣି 17 ବର୍ଷ। It's all like yes. बाकी usual order जो report to be called for and
Another appellant is Kasinath Lori.
where is that?
I'm praying for move for both the appellant.
No, we are granting bail only to this lady. You have filed this application for bail for the two appellants.
My lord.
1756.
A joint of
However, in view of the available material on record against appellant number 2, Kashinath Luhari, we are not inclined to release him on bail. Yes. So A1 granted bail for 3 months. A2 rejected. Yes, next.
May I please, Item 41.
In this case, your lordship is directed to collect the criminal antecedent matter. On 18th it was passed, so we have sent the letter on 19th. I pray for Thursday, madam.
Okay, next week, next week. The Learned Council for the state submitted that as per the order dated 18/7/2024, instruction has already been sought for regarding criminal antecedent, if any, against the appellant, and the same is awaited, and the matter may be taken up next week. In view of such submission, place this matter in the week commencing from 29th of July 2024. Yes.
Item 42.
Item 42, may I please, your lordship. Solo appellant. Petitioner is undergoing sentence under section 302 and is in custody since 19/5/2016, and the date of occurrence is
What is the date of custody?
19/5/2016. Sir, I found from the charge sheet.
Okay, and you have been found guilty under section
302, sir.
302. Okay.
Sir, the custody period is just above 8 years, 8 years and 2 months. And
We'll come to paragraph number 2
my lord,
of the influence judgment.
my lord.
Please place the paragraph.
The prosecution case in short.
Yes.
The prosecution case in short is as follows. The informant, Babita Malik, is the sister-in-law of the deceased Mansi Malik. The deceased is the wife of the accused. The deceased was residing in the house of the informant along with her 2 sons for the last 5 months, as there was family disturbance between the deceased and the husband. On 18/5/2016, at about 4 p.m., the son of the deceased told the informant that the accused was asking something to his mother in agricultural field. Then they went to Bari side and noticed that the accused Sulaba Malik was assaulting by means of katuri. They rushed to the spot and seeing them, the accused fled away from there, and they noticed deep cutting injury on the head and neck of deceased, and she was lying in the paddy field in bleeding condition. On the basis of written report submitted by the informant, FIR was registered.
So who is the eyewitness?
Your lordship, as per the judgment, PW 11 and 12 are the eyewitness.
PW3, 11, 12 and 15.
PW3.
Sorry, well, PW 11, 12 and 15.
15.
He is the informant. PW 11 is the mother-in-law of the deceased.
11, 12 and 15.
11,
and who is the doctor who conducted PM?
So PW 21.
So first let us go to the doctor's evidence.
My lord.
What, how many injuries you have caused to your wife?
My lord, general observation, rigor mortis was present in all limbs.
You come to the external injuries.
External injuries.
See the
2 lacerated wounds over left palm, posterior, involving deep muscle and structure, size 3/2 inch, 2/2 inch, and lacerated wound on face right side.
Right side mandible.
2 lacerated wounds on front side, 1 deep involving deep structures, 1 lacerated injury over left shoulder, 2 lacerated injuries, size on posterior aspect of neck, involving the deep structures of neck. lacerated injury on right shoulder, contusion of size 2 centimeter, side of chest wall, and 1 contusion of size half centimeter and half centimeter on left side of chest wall.
And the cause of death was due to shock and hemorrhage and multiple deep injuries.
My lord. My lord, the cross-examination part is also important. At the time of post-mortem examination, cautery was available with me for examination. I do not remember whether the cautery was stained with blood or not during my examination. The cautery was produced before me in open condition. I handed over the said cautery to police after examination. It is not a fact that the injuries found on the body of the deceased is not possible by dashing against a vehicle also and fall on the rough surface.
So what is your story? Was he going in a vehicle met with an accident?
So my story, as per it was a family dispute. There was
the suggestion that was given to the doctor that it could be possible by dashing against the vehicle. Whether it is an accident, right now the beginning you have taken or what?
So we not the person, not the accused who has stated this, but sir, in further examination, some witness must have stated this. That is why.
Not must have. You find
Sir,
out.
I will find out. Sir, I will find out.
When 3 witnesses to the occurrence have stated against you that you are the person who assaulted your wife by means of a cautery on different parts of the body, which is getting corroboration from the doctor who has conducted post-mortem examination, that is PW 21. So the manner in which you have caused the assault is from the top to bottom you have assaulted, and neck structure, head, right, ଉପରୁ ତଳ ଯାଏ ଆଉ କୋଉଠି ଛାଡି ନାହାନ୍ତି ସବୁ.
Sir, while dragging some injuries. Because
By dragging.
So there is
These injuries could be possible by neck and how this
These are all lacerated wound on the, and impact has been, see this impact.
Sir, on last occasion, 13/1/2023, he was released for 1 month on account of his mother's demise.
No, that is all right. You are now arguing the matter on merit. So
My lord, I am pushing for 389. IA 97 was pending ever since. IA number 97 of 23 was pending due to call for lower court records. It was still pending from that
IA 97.
My lord, on the same day, 13/1/2023, re order be hit.
IA number kon 97 kon.
The application for grant of bail to the my lord, interim application was filed in between because mother died in between. Then IA number 97 is there. So the interim bail number is 105 of 2023.
IA 97 also your prayer is the appellates, therefore praise that your lordship would be restricted to allow this interim application.
Sir, interim
97.
Sir, IA ro full form ta lekhi dechi full sir. Interim application, interim bail.
No, it's all right, but this is it's not a prayer which has been made on any health ground. It is a matter which is to be adjudicated,
Sir,
whether on merit you are entitled to get the bail or not.
Sir, my humble prayer is considering my period of custody. So I humbly pray.
Oh, 8 ବର୍ଷ ହେଇଛି.
Sir, 8 years, 2 months. And no antecedent is there as per my instruction.
The question of killing of his wife.
And if you go, then what would happen to those 3 persons who has deposed against?
Sir, not habitual offender, sir. Family dispute. Many provocation have happened between husband and wife, and some act he has done. He is not a person who is a ill-willed person. Sir.
No, in that case, you could have seen that she is taken to task, but you do away with her life entirely and with a brutal.
Sir, I am not, sir, asking this.
Number of assaults are there. Had there been one assault, right, and she died.
Sir, I agree, sir.
Then we can say that yes, but
Sir, I agree,
Not
sir.
allowed to.
Sir, I agree, sir. Sir, 3 eyewitnesses are there, sir. During final hearing, I'll try to get it. Until then.
Are the learned counsel for the petitioner, learned counsel for the state? The learned counsel for the petitioner submit that the petitioner is in judicial custody since 19/5/2016, and the eyewitnesses to the occurrence are PWs 11, 12, and PW 15, who have stated that the petitioner, who is the husband of the deceased Manasi Malik, assaulted the deceased with a cautery, and but the doctor PW 21 has noticed all lacerated wounds and contusions on different parts of the body, and the which might suggest that the sharp side has not been used, and therefore the bail application may be favorably considered. Learned counsel for the state, on the other hand, oppose the prayer for bail, praise the evidence of the eyewitnesses. So also the doctor PW 21 and stated that doctor examined cautery, which is the weapon of offense produced before him by the IO, and has specifically opined that the injuries sustained by the deceased would be possible by such cautery. Considering the submission made by the learned counsel for the respective parties, the evidence of the eyewitnesses coupled with the evidence of the postmortem, the doctor who conducted postmortem examination, and the number of injuries sustained by the deceased, while not inclining to release him on bail on merit, but taking into account the period of detention for more than 8 years. And since the appeal is of the year 2023, and there is no likelihood of it being taken up for hearing, we are inclined to release the petitioner on taking into account Letty versus Swanson. We are applicable. We are inclined to release the petitioner on interim bail for a period of 3 months.
4.
And the while on interim bail, he shall not try to come in contact with any of the prosecution witnesses examined in the trial court, and shall not indulge in any criminal activities. Violation of any terms and condition shall entail cancellation of bail. Yes.
Sir, kindly 4 months.
Make it 2 months.
3 months. 3 months, sir.
3 months or 2 months. Yes. Next.
Item number 43.
Lord, this matter, madam, is the last occasion directed that to obtain that criminal antecedent as well as the conduct of the accused and also the custody certificate.
80 ಕೊಟ್ಟಿದೆ.
Nothing adverse. Baki custodial.
7 years, 10.
7 years?
10 months.
7 years, 10 months. Yes, Mr. Panda, what do you say?
He is also languishing in custody since 20th 10 2016 and basing on a circumstantial evidence.
What are the circumstances against you?
Circumstances that in the last night there was a melody party, and also out of intoxication the deceased and the present petitioner, they are quarreling each other, and the matter was just settled between them by the persons Thereafter, in the next day, the dead body was recovered. Only last thing to nothing.
And the weapon was seized from a
Then
forest.
he was there serving there. He was
Let him argue.
yes.
One is last scene.
Last scene and another leading to
Who has stated about last scene?
PW 5678.
PW 5, 6, 7, and 8. And leading to discovery of weapon of offense.
Weapon of offense from the forest department office.
What is that weapon?
The weapon is yes.
Iron X with wooden and all night.
He was serving in the
Tangia and
peat house. That was the peat house.
16.
What is the name of the deceased?
Sudhir Kahar.
Sudhir Kahar. They have stated that at about 12 o'clock, no, at about so we saw Jaswanta means the appellant. And Sudhir was going towards Jatra field. Acha. এই গোটে ଅଛି ଆଉ ଗୋଟେ ହଉଛି ସେ ଯୋଉ weapon.
Weapon seized from a forest beat house where he was working.
He was working there in that forest department. He was one of the employees.
So there was some quarrel, but that subsided. Then both of them went towards the Jatra field. So
they were leaving that place. That was seen by one of the witnesses.
While leaving Jatra.
Well, PW5.
No, Jatra ଦେଖିବାକୁ ଯାଉଥିଲେ ଲେଖା ହେଇଛି.
PW ଦେଖିବାକୁ ସମସ୍ତେ ଯାଉଥିଲେ.
ହଁ, PW5 ର evidence
saw that quarrel and
quarrel subside କଲେ ପରେ ଏମାନେ ତାଙ୍କୁ separate କରିଦେଲେ. Separate କଲା ଆପଣ କହୁଛନ୍ତି. ତାପରେ ଦେଖନ୍ତୁ 10ଟା ବେଳେ PW5 ର evidence କୁ ଆସନ୍ତୁ. The time was around 10 PM in the night. Thereafter we, that is myself, Prakash, Sudhir, Jaswanta, Mrutyunjay, Narottam, went to the Jatra field as the melody program started. About 1.5 hours after we saw that both Jaswanta and Sudhir going together from the Jatra field. It was at about 12 o'clock. And on the next day, the dead body was found. Which place?
W15 and 9.
FIR ଲେଖା ହେଇଥିବ dead body କୋଉଠି ମିଳିଲା? ମୋର ସୁଧୀର ଭାଇଙ୍କୁ ମର୍ଡର କରି ଆଚ୍ଛା ବଣିଆପଡା ପାଖ ବିଲରେ ପକା ହେଇଛି। ଦେଖିଲୁ ଯେ ସ୍ୱାମୀ ସୁଧୀରଙ୍କର ଶ୍ୱାଂଶ କଟା ହେଇଛି ଏଠି। ଆଚ୍ଛା ପଡିଛି ଅଟାଣା ଜାଗାରେ। Are the learning counsel for the petitioner, learning counsel for the state, the in persons of the order dated who order ହେଇଥିଲା criminal antecedent
एक साथ 2014
एक साथ in persons of the order dated 1/7/2024 the learning counsel for the state has produced the written instruction received from the inspector in charge of model police station Baud from which it reveals that there is no criminal antecedent against the petitioner. The same is taken on record. The learned counsel for the state has also produced the custody certificate from the Superintendent District Jail Board, which is dated 2/7/2024, and it reveals that the period of detention is 7 years, 10 months, and 4 days. The custody certificate is also taken on record.
And a conduct certificate also.
On deliberate?
Custody and conduct.
Conduct certificate.
Last page.
Acha, the learned counsel for the state. Acha, wherein ऐसी जो custody certificate रखी दियंतु, custody certificate, a conduct certificate of the petitioner has been filed, which mentioned that he is a very disciplined person. The certificates produced by the learned counsel for the state is taken on record. The learned counsel for the petitioner submitted that it is a case based on circumstantial evidence, and the two circumstances are the last seen of the appellant in the company of the deceased, which is deposed to by PW 5, 6, 7, and 8. And they were seen leaving the Jatra field where a cultural program was going on.
Melody program.
A melody program was going on. And another circumstance is leading to discovery of the arcs. It is submitted that there are good chances of success in the case, and balance of convenience is in favor of the petitioner. And the place where the dead body was lying is Koti Saramilla,
open field.
In an open field. And the circumstances are not clinching, and therefore the bail application may be favorably considered. Learned counsel for the state, on the other hand, opposed the prayer for bail, placed the evidence of the doctor. Case at postmortem jo kale, PW 15 who conducted postmortem examination. So also the evidence of the witnesses to the last scene. Considering the submission made by the learned counsel for the respective parties, absence of any direct evidence, nature of circumstantial evidence available on record, and period of detention of the petitioner in judicial custody, so also absence of any criminal antecedent, we are inclined to release the petitioner on bail allowed.
Obligement.
Item 44.
Next.
Item 45.
44. 44 kali 45 विजय कुमार महांती को एंगेज करिया पई प्रिजनर्स पिटिशन आछि नंबर देना थी विजय कुमार महांती किए इबे देखंतु तांको टिके ए जो टेलीफोन डायरेक्टर बार रो जो अछि विजय महांती केते जण थिबे ना मिस्टर दास ये प्रिजनर्स पिटिशन आछि फॉर एंगेजमेंट ऑफ एडवोकेट विजय कुमार महांती तेणु से किसी मोबाइल नंबर दे ना थी वो विजय महांती कहउछन देखन जदी कोन है ना नेक्स्ट
Item 46.
एमन कोन हमें एंगेज करथलु विश्वजीत त्रिपाठी ना की एंगेज करला ना प्रिजनर्स पिटिशन विश्वजीत त्रिपाठी को सी एंगेज करियो पिटिशन देइथिला एवं तापर विश्वजीत त्रिपाठी मध्य वकालतनामा फाइल करचंती and his mobile number has also been given. So ask him why he has not filed an interim application for condoning the delay. There is delay of 66 days. We'll take up this matter tomorrow. Yes, then.
Item 47.
Item 47, may please. On the last occasion, my lords, your lordship has directed the state council to obtain the criminal antecedent and the custody certificate.
I prefer Thursday, man. I've already asked for it.
Okay,
CA has come, but
the Land Council for the state wants it on Thursday. That means it will be taken off on 25th of July. Okay, from this weekly list. All right? Yes.
Always.
Item 48.
Item 48, I am appearing on behalf of Mr. L. Misra. I am praying for next week.
All right. Mention is made on behalf of Mr. Lalitendu Misra for adjournment till next week. List this matter in the week commencing from 29th July 2020.
Item 49.
58.
May it please, Your Lords. On the last occasion, Your Lordship has been pleased to direct the London State Council to produce the custody certificate and antecedent. And as per my instruction is custody since 8 years, 7 months. And also instruction was not released during COVID, my lords.
Okay.
Yes, Mr. Tripathi. On Asila.
8 years, 7 months. In
And what about C, criminal antecedent?
No criminal.
No CA. Okay. (49) CRLA 213 of 2024. Jagannath Maharana. Sole appellant.
Let's.
So, what is the offense under which you have been found guilty?
302, let's see.
302.
Let's see.
Okay. And what is the name of the deceased?
Kaducharan Maharana.
Kaducharan Maharana. Date of occurrence is 7/12.
Let's see. The custody is 9/12.
No, it's all right. 2015. Is it a case based on direct evidence or circumstantial evidence?
Direct evidence.
Direct evidence. Who are the eyewitnesses to the occurrence?
PW 1, 2, 7 and 9.
1, 2, 7 and 9. Who is the doctor who conducted PM?
PW 23, let's see.
PW 23.
Let's see.
So, you assaulted the deceased as per the eyewitness version with what weapon?
Knife, let's see.
Knife.
Let's see.
How many blows you have given?
No, doctor. There is two injuries, Millers.
2 injuries.
Let's see.
Both are on the belly.
Penetrating injury.
Penetrating injury.
Citrolate hypochondry. Another is one penetrating injury, 3 inch, 2 inch in the size of anterior aspect of right ventricle. But in cross-examination, PW 23, let's see.
Why you assaulted the deceased?
Lord, to assault parts of our PW 1, this wife says, my lord, there is no previous enmity. And 2 persons, my lord, Suduru and Balaram, my lord, they caught hold of the deceased and the petitioner appellant staff, my lords. And,
what happened to the other 2?
Other 2, my lords, they have not been charge sheeted, my lords, and also they don't have
Okay, you are the only person charge sheeted.
Yes.
And what is the impact of the 2 knife blows? What penetrating injury? 2 inch into 1/2 inch abdominal cavity. Okay. 8-3 left side along with the muscles also. Anterior surfaces. Pericardium inside 1 penetrating injury. On the right ventricle, both the chambers and so.
But in cross-examination, doctor says only 1 penetrating injury.
In the cross examination, doctor says one penetrating injury opening.
So far as the external appearance of the deceased is concerned, there is only one penetrating injury opening to the abdominal cavity. Okay.
And so far depositions are eyewitness are concerned, there is no previous enmity also. Wife says and also darkness is also coming, Millards. In the cross examination, which were not believed, Millards, because it's a 6:30 p.m. evening.
Are the learned counsel for the petitioner, learned counsel for the state, in pursuance of the order dated, is it a previous order? 9/7/2024, the learned counsel for the state has produced the custody certificate received from Superintendent Subjails Surda, which dated 14/7/2024, which indicate that the petitioner custody period is 8 years, 7 months, and 6 days. He has also produced the report from the IIC Bodgaoda Police Station, Ganjam, which indicate that there is no criminal antecedent against the petitioner. The reports produced by the learned counsel for the state are taken on record. The learned counsel for the petitioner submitted that the petitioner is in judicial custody since 9/12/2015, and the occurrence in question took place on 7/12/2015. And as for the evidence of PW1, there was no previous enmity between the petitioner and the deceased, Kanhu Charana Maharana. And on the date of occurrence, the petitioner stated to have assaulted the deceased by means of a knife on the abdomen. And though it is the case of the eyewitnesses that 2 blows were given by knife, but the doctor bracketary PW23 who conducted post-mortem examination has stated that from the external appearance of the deceased, there is only one penetrating injury opening to the abdominal cavity over the left hypochondrium. Stop. Considering the submission made by the learned counsel for the state counsel submission note करेगी? Okay. Considering the submission made by the learned counsel for the respective parties in view of the evidence of the eyewitnesses, so also the post-mortem report finding, while not inclining to release the petitioner on bail on merit, but taking into account the period of detention in judicial custody and absence of any criminal antecedent against the petitioner. And also, since there is no chance of early hearing of the criminal appeal in the near future, we are inclined to release the petitioner on interim bail for a period of 3 months, subject to condition that he shall not indulge in any criminal activities and violation of any terms and conditions shall entail cancellation of bail, stay realization of fine. Yes, you'll 3 months for a date fix up kar debe. You'll file the surrender certificate. Yes. And report to be called for from the concerned OIC regarding his conduct while on interim bail. Yes.
This name of the deceased is Kalu Charan Maharana.
ମୁଁ କଣ ଡାକିଲି କାହ୍ନୁ ଡାକିଦେଲି ଆଚ୍ଛା କାଳୁ ଚରଣ ମହାରାଣା. Okay.
Grateful.
Item number 50.
50, Mr. Durga Prasanna Misra. Not there. Yes.
Deposition copy भी देना.
देना दी. No, you collect it. Give the pen drive and collect.
ठीक.
Yes.
Item 51.
Same deposition copy required.
Some copy has been solved, my lord, yesterday.
Please collect it in your pen drive.
Thursday আসছে এটা।
এটা Thursday যাচ্ছে। Okay. So then both the matters,
Thursday.
this 50 and 51 will be called on 25th of July 2024. Okay. এটা কিছু লেখা হবে না খালি। Mr. Mahanti, which is the item?
52, they are in opposite track.
What is this case?
Probably specially alerted to your lordships
Huh.
because
Lord, I appear for the petitioner.
the petitioner.
Yes.
Lord, the case has a checkered history, but just because of the shortage of time, may I just capsule it like this? There is admitted shortfall, Mullards, in the grant of the lease of the area of the lease, and the shortfall is about a staggering almost 19 hectares or what. Now, Mullards, let's leave the merits aside. If your lordships were be kind to see the last order, Mullards, on the 1st of March 2024. Or Mr. So-and-so.
Which order dated Land Council?
Mullards, 1st of March 2024. Mullards, 1st of March.
1st of March 24.
That's right.
Okay.
Married, Mullards?
Just a minute. 1st of March 24 order kind? Scanning है नहीं की? Yes.
Or Mr. Sharma, learned senior advocate, appearing with Mr. A.K. Mohanty, Mr. Parija, learned advocate general, along with Mr. Mohanty, additional government advocate, so and so, Mr. Mohanty, learned senior advocate, Mahapatraji, Padhesha, and Nandaji. Mr. P.P. Mohanty, learned additional government advocate, files a reply affidavit on behalf of the opposite party in court. On the basis of such reply filed by the opposite party, all the parties have agreed to sit together and explore the possibility of an amicable settlement of the dispute between the parties outside court. In view of the above, this court permitted learned advocate general as well as learned senior advocates appearing for the respective parties to sit together, come up with a solution so that the matter can be disposed of accordingly. Call this matter after 3 weeks. Mullards, the learned then Advocate General Mullards did call a meeting. All of us did meet in his chamber. The meeting was well attended, Mullards, and notes were taken. All views were expressed by all the parties. But thereafter, Mullards, due to subsequent events, the matter is there. That's where we stand. Now, Mullards, if there is some solution which has been found or some lowest common denominator which has been arrived at by the then Advocate General Mullards, he could put it on record. If not, he could also state that on record. And subject to the way forward, Mullards, since the court felt that this matter should be sorted out, this is where we stand, Mullards. Now we are completely in your lordship's hands.
So, according to you, you have no instruction or information regarding the development?
No, Lord, we don't have, Lord, because of the subsequent events and the...
Don't have. We also don't have. We all were there, but there was a meeting on which
In fact,
might adjust.
claiming against the shortfall. So it was agreed that so far as both of us are concerned, since our land is the leasehold land is neither in excess nor in less. We had no objection to whatever settlement is there.
Extra amount land can be given in lieu of his shortfall that the state was exploring.
That
the state was exploring.
Or compensation or state. I don't think
because
Mr. Das will be able to make any statement on
because the yesterday new Advocate General joined, my lord. So they have taken charge, my lord. So I will discussion with him. Then let it be urgent to any other day, so we can.
So if you think any date next week can be.
Mr. Singh can suggest the date. We are locally available, so Just saying, give them a week's time to get back to
The
my
new age is joined yesterday. That is the submission of the London Additional Government Advocate. So 1 week time at least is required for him. So if you all three agree, any date can be fixed in the week commencing from 5th of August 2024.
Yes.
Any day.
Lordship can keep it in supplementary list so that
It will supplement a list obviously on Tuesday.
Well, if your lordships could be kind enough, Lord, because I wish I was also a local Malad in the Holy Land. But physically I am not, but by spirit I am. If your lordships could be kind enough, Lord, 16th of August.
All right.
It's for us no difficulty. Lordship give 16th, where they also have a little more space and time.
All right. The Learning Council, Mr. Chetan Sharma, appearing through virtual mode, place the order dated. Say order.
Can it be?
Yeah, Mr.
What is the order
Mr. Singh,
dated?
can it be? I'm not 16. Mr. Mahanti has some difficulty on 16. I just
15, 16, 17.
Holidays.
16th, Mr. Mahanti has some.
What he say that there are 4 to 5 holidays. 15th is a holiday. Then 17th, 18th, 19th are holidays.
So can it be
So
20th or
can it
21st?
be any other date if you suggest it can be
But
taken?
the point would be it would not be argued on merits. My respectful submission is this. We will not be touching the merits. We will only be saying, my lord, whether there is a settlement or not.
Mr. Mahanti, Learned Senior Advocate, has some difficulty he's expressing. So that is why he's telling that any other
If
date.
we call it on the 16th, my lord, we'll take a date thereafter, but at least we'll know on the 16th where we stand.
Whether it would be possible if it is taken up on 14th for that purpose for some time.
Very well.
Okay. You place that order, the last order you just placed. What is the order dated?
And 14 2 p.m. better.
Okay. No, we are just seeing that. The order should be scanned immediately. All these orders, which has been.
1st of March.
The order which you placed is dated
1st of March 2024.
In WPC number 13486. Which order? It was.
14 ही था.
देखिए से ऑर्डर टा देखिए 14/3 ना कौन को थे.
So that is number 2017 writ petition, Your Lordship.
No, there is one order. Oh, that is not there.
Nah, 14th order.
No, there is a slight, there's a contentious matter here, Lord, on the 14th.
Just want to which order you placed and okay.
Main trail asini bra. Ito jo software 2 14 mention करने वाली. Job is plan देगा.
Connected by thread.
Which one? अच्छा.
Lord, could your lordships
okay, that is
consider the fact
WPC number, the second item, 26000 of 2017. Hala? Mr. C. Sharma, and senior advocate, submits placed the order dated 1/3/2024 and further submitted that pursuant to such order, the parties sat together to explore the possibility of amicable settlement of the dispute between the parties, but is not aware about the latest development and the matter may be taken up in some other day. Mr. Das, Land and Additional Government Advocate submits that since new Advocate General has joined yesterday, the matter may be taken off in the month of August, so that he will apprise this court about the development made as per the order dated 1/3/2024. Mr. Ashok Mahanti, so also Mr. S.K. Padil and senior advocates are present for opposite party number 4 and 5 respectively. On consensus of all the parties, list this matter on 14th August 2024. The matter will be taken off at 2 p.m. That's all. 14th of August 2024 at 2 p.m. along with these other WPCs. Okay.
And Lords, if the learned government advocate can also bring into court, my lords, because some record of the minutes or if some decision has been arrived at by the there is some if there is, then my lords, we can take it from there. Otherwise, then it's a new start. Either your lordships will then hear us on merits and decide either which way.
If there is any document available regarding the discussions between the parties for amicable settlements, the Land and Council
and
for
any
the
decision taken thereafter by the government.
and any decision taken
Yes,
up
correct.
by the government, the same shall be produced on the next date. Okay.
Correct.
Grateful.
Lordship.